code, my lord.
Same footing.
Other four, my lord, the phone calls and all these things has been made.
They were not directly related.
No.
You are driving the vehicle.
Yes, I am running the vehicle. It is true, my lord. And my lord, I have been detained and the
मटेरियल क्या था?
चार्जेस अभी फ्रेम नहीं हुआ है तो कितने टाइम लगेगा?
You are languishing in jail since
my lord 11th of December 2019, my lord.
4 years.
What was the material recovered from you?
My lord, 391.4 kgs of ganja was recovered from the truck, my lord. And if your lordship kindly takes pain to the complaint from my learned.
You are driver of the truck?
I am driver of the truck.
And person in charge?
My lord.
Who is the owner of the truck?
My lord, he has not made accused, not made accused.
Not made accused.
And my lord, on 11th of December 2019.
But who is the owner? Whether you are also owner of the truck?
That I have to take instruction.
Are you also owner of the truck?
That I have to take instruction, my lord. And my lord, on 11th of December 2019, when the seizure was made, my lord, I have to be produced under section 57 of the CRPC within 24 hours before the nearby magistrate, my lord. But I have been produced in the nearby magistrate at Malda Court, my lord, on 13th. And 13th was FIR was registered, my lord. Although from the complaint, your lordship find from the case diary that seizure was admittedly made on, my lord, 11th of December 2019. Although the arrest was shown on, my lord, 13th of December 2019, and I have been produced before the learned court on, my lord, 13/12/2019.
When was the charge sheet filed?
Charge sheet, my lord, charge sheet filed on 3rd of December. Complaint, my lord, 3rd of December 2020. Just, my lord, a few days after, my lord, within 1 year, my lord. Few days back within 1 year. 2020 complaint file and 2023, my lord, December is the next date fixed for, my lord.
Petition is to charge 7 charge frame.
And the next date is fixed for only for production and appearance, my lord. No date has been fixed for framing of charge yet also, my lord.
Let us hear the NCB.
Yes. So what do you say?
My lord, in my respect to submission, my lord, they have 3 things. My lord. First of all, my lord, what I am trying to point out very humbly before your lordship, thrice bail application has been rejected. And all these points have been taken into consideration by this honorable court. And lastly, the bail was rejected on 6th of July 2023. All these points, my lord. Now, my lord, the second branch which I will amplify is, my lord, that one cannot be allowed to take advantage of his own wrong. What happened is they challenged the proceeding by way of a revisional application before this honorable court in 2021.
No, not 21.
22, I stand corrected. My lord, may I? I'll not speak something which is off the record. 2022. That application was kept here and the records from the trial court were called for by this honorable court. That matter was kept pending before this honorable court for years, and that was simply after that withdrawn by the petitioner from this honorable court. My lord, I'll take, my lord. And then, my lord, after that, my lord, only in the month of August 2023, the records reached the learned trial court. And after that, my lord, the documents were to be given, but the accused persons did not appear on the last date. So what is happening is, my lord, they are taking advantage of their own wrong. And, my lord, first I'll amplify on the orders by virtue of which the bail application has been rejected, my lord. First of all, he is the driver. In his custody, the entire things were there, my lord. Now, my lord, will kindly come to page. First rejection, my lord. Will kindly come to first page 15, my lord. The page 13, my lord, of my lord's brief. 6/5/2022, my lord. First point which they had taken at that point of time, that the charge sheet was, the time for filing charge sheet was not extended, which was put to rest by this order. My lord will take page 13 of my lord's brief, my lord. Order date is 6/5/2022. Lordships have got it. My lord, the third paragraph, my lord. Fourth paragraph from the top, my lord. Learned advocate appearing for the NCB submits this pursuant to an application for extension of time to submit the complaint. The same was granted. The time to submit the complaint was extended on May 27, 2020. The complaint was filed within the extended time. Now, my lord, then after that, the petitioner herein played for default bail on June 16. The time for submit complaint was extended by order dated May 27, 2020. The complaint was ultimately filed on December 3, 2020 within the extended period of time, and therefore the question of the petitioner being enlarged on default bail does not arise. Consequently, the bail was rejected. Now, my lord, the second order, my lord, page 15, my lord, will kindly come. All those points have been taken into consideration. The order dated 23/2/2023, page 15 of my lord's brief. My lord has got it? Yes. My lord will kindly, I may be allowed to read paragraph 3, my lord. From the materials on record as well as the report, we note narcotics above commercial quantity was recovered from the petitioner. Petitioner does not stand on the same footing with the co-accused who are on bail. Petitioner has contributed to the delay. Proceedings are installed due to revision petition being CRR number 2421 of 2022 filed before this court. Now, this was one of the grounds. Now, can you see, under the such circumstances, we are not inclined to grant bail to the petitioner either on parity or on the ground of delay. Now, subsequently thereto, the last order. Then, my lord will kindly see the order at page 17, 6/7/2023, 4 months back, 3 months back rather. Lordships have got it? Page 17.
Same thing reiterated in 2 sentences.
So, my lord, all these points have already been taken into consideration by this honorable court and nothing has changed. And now, my lord, I will show why they are saying about delay, my lord. If my lord kindly comes, my lord will kindly come to page 19 because pagination was not properly done in my brief, my lord. Just page 19 if I'm not mistaken, my lord. The order dated 20th of April 2023 passed by my lord Justice Vivek Chaudhary, my lord. This is passed in CRR number 2421 of
Division was dismissed for non-prosecution.
Yes, my lord. So, my lord, and then you file a revision, and then, my lord, I will take my lord to the last orders which has been annexed by them. My lord will kindly come to the order sheet, which has been, it has not been paginated, my lord. My lord, the order sheet of the learned trial court, my lord, in NDPS case number 38 of 2019. My lord, have got the order sheet, last, my lord, of the trial court. The order sheets which have not been paginated, my lord. After page 26, my lord.
Yes.
Lordships have got it, my lord?
Yes.
My lord will kindly see here, my lord, the last but one line, if my lord kindly reads, my lord, or allows me to read on 28/7/2023, original case record, last but one paragraph. Original case record has not been received from the honorable court. So, my lord, where lies my mistake? Now, my lord, after that, my lord, for production appearance, and then I will kindly come to the next page, my lord, 28/8/2023, my lord. We'll see the order date. Then, my lord, last but 3 lines, my lord, 4 lines, my lord. Original order already has been received. So, when it was received, my lord, on 28/8/2023, my lord. And then, my lord, what happens is the next order, my lord. I have got my own compilation which will speak volumes, my lord. But before that, what is crystal clear from the petition itself. Now, my lord, the last order, order number 51, my lord. Last page, last but one page, order number 51, my lord, 11/10/2023, my lord. Why? Copy has last but 2 lines, my lord. Copy has not been supplied to the accused person due to absence of accused person. Now, my lord, I cannot be held responsible in an orchestrated manner, my lord. They are delaying the trial. And, my lord, he is not on the same footing, my lord, because of the reason that the persons who have been released on bail, they were not in custody and the recovery was not made from them. Now, my lord, we kindly see. They are saying that 188 days, my lord, charge sheet. Now they have, though they have mentioned that point over there, but then, my lord, that is also a false thing which they have stated on affidavit. Before the Supreme Court, when they went, my lord, they have said that they were not given a chance. And in this petition, they are saying that 188 days, that extension was not allowed.
Where is the order of Supreme Court?
My lord, so my lord will kindly see, my lord, I'm taking you to my lord to that. My lord will kindly see page 18, my lord, page 17, my lord. That was not pressed. They went also up to the Honorable Apex Court. On the ground that extension, here they are pleading in their petition that extension was not. My lord will kindly see page 18, just before the order passed in the revisional. My lord will page 17 if I am not mistaken. Pagination is slightly. I apologize.
18 is Supreme Court.
My lord, 18 is Supreme Court, and my lord will see 11/12/2020, where what they say, my lord, there. Learned counsel for the petitioner, that is Mohammed Chand, again the petitioner, on instruction states that order dated 27th May 2020, extending the time for filing the charge sheet by another 180 days, was passed without notice and without hearing the petitioner. Here they are saying without hearing. And in the petition before my lord, what they have said? This cannot be allowed, my lord. My lord will kindly see. My lord will kindly come to page 5 of the petition. My lord will just tally the two submissions before the Supreme Court and before this Honorable Court. My lord will kindly come to page 5, paragraph 6.
My lord,
Here in paragraph 6, they are saying
so far
that extension was not granted. And they have got certain things, certain information set from the trial court, where it has been said that NCB has falsely stated before this Honorable Court that extension was granted. This is something affirming on oath which is false.
In the period of incarceration, that ground.
And my lord, there are only 6 witnesses.
7.
He's on a different footing. He's on a strong.
কজন আছে দেখ?
7.
He's a personal position.
And
Actually, simply as a last July, as well as there.
and my lord, there are only
My lord,
7 witnesses.
So far the delay
If
caused
you-
by the petitioner, as my learned friend has said, my lord, I have been arrested on 2019, December 2019, my lord. My lord, kindly,
Your revision was pending all
my
along.
lord, when the revision was filed, my lord, I am taking that, my lord.
My lord,
Please
before
speak-
that
my-
Supreme Court,
just a minute. My lord, the petitioner was arrested on 11/12/2019. After 2 years and 8 months, this revision was filed on 7/7/2022, my lord, and it was withdrawn on 20th of April 2022, my lord. My lord, as regards to 2 years 8 months, my lord, what the prosecution did, my lord. But I am putting question to myself, my lord, what is the justification of the prosecution, my lord, as regards to the 2 years 8 months? My lord, I have very well, my lord, I have delayed for 8 months only. That is, my lord, from 7/7/2022 to 20th of April 2023, my lord.
7
My lord.
witnesses in total.
my lord, may
Seven.
I answer a simple
As of
answer
date,
to
the
this?
charge has
My
not
lord will
been
again
filed,
take up page 18. My lord will take up page 17. This will quench the queries of my learned friend. Page 17. My lord will see the Supreme Court application, my lord. The date is on 11/12/2020. 2020. They went to the Honorable Supreme Court. 19, he has been arrested. Now he's saying that he has come before this Honorable Court in 2022. And then after that, he has tried his luck in
Would it
2020.
be reasonable to expect that the trial would be over by 1 year?
My lord, because only
7
7
witnesses.
witnesses are there. My lord, what happens, my lord, I vouch for it, because in all the CBI cases, my lord, we have already asked this Honorable Court to fix up a layer because my lord, 7 witnesses are there, my lord. And my lord will kindly see the order sheet. It is due to the delay caused by them. Now they cannot champion for the cause which will help them, where they have committed the delay. They are not allowing us.
Delay हुआ है और 1 year का expectation रखते थे. 7 witnesses of
7.
So the expectation that the trial will go.
And my lord, 7th month, my lord, this Honorable Court has rejected. There is no change of circumstances.
We are rejecting
7th
the
month.
bail- We are rejecting the
This
bail
is
application.
overkill.
We are rejecting
apologize,
the bail
my lord.
application.
Exuberance.
And expecting the trial to be concluded. Charge sheet to file over.
Charge sheet file. Charge sheet.
Yes, my lord. It has been filed in the
3rd of December 2020.
2020, my lord.
With expectation that trial be concluded within a year.
I'm indebted, my lord. I apologize, my lord. Exuberance, my lord. Old age exuberance. Huh?
Third Shri.
Molay Bhattacharya.
Reject করে দিল।
Molay Bhattacharya.
আপনাদের second.
भाई क्रिकेट है
Council नाम का
চিন্তা করছো
अमन
Record.
এটা কি হবে একটা মজাই আলাদা আছে
धीरज अमीन
Third Shri Molay
Molay Bhattacharya.
Bhattacharya, learned counsel for the applicant, and Shri
Dheeraj Trivedi. Dheeraj Trivedi.
Dhiresh Trivedi, learned
নামটা বলো
He's the Deputy Solicitor General.
my lord
learned Deputy Solicitor General, Government of India. This is the fourth time that the bail application has been filed by the applicant, petition, by the applicant praying for bail
সভ্যতা বলে দিচ্ছে
in case in NDPS case number 2019 arising out of NCB crime number 23/NCB/KOL/2019 dated 13/12/2019 under section 8 within bracket small c read with section 20 within bracket small b next small bracket में Roman 2 next bracket capital C oblique 27 capital A 28/29 of the NDPS Act 1985 pending in the court of Judge Special Court additional additional district judge fourth court Malda Malda Thereby THEREBY stop so fresh para the learned counsel for the applicant submits
मालदा ही है thereby
अच्छा मालदा वो देयर बाई नहीं है मालदा है और देयर बाई मत लिखिएगा मालदा लिखिएगा देयर बाई ये
वो तो ठीक
देखिए learned counsel for the applicant submits that the applicant is languishing in jail since 11/12/2019 and charge sheet has not yet been filed.
charge has not been framed.
Charge has not yet been framed. List of he submits that on account of such a long delay in framing the charges, comma, the applicant cannot be allowed, cannot be on account of what have long delay, comma, in submission of in framing of charges, comma, the applicant deserves to be enlarged on bail. Please stop. He further submits that other co-accused persons have been granted bail. Please stop. Fresh para learned Deputy Solicitor General of India has vehemently opposed the bail and please stop. He submits that the delay in framing of the charges is totally attributable to the applicant. Please stop. It submits that bail application of the applicant was rejected twice by orders dated 6/5/2022, comma 23/2/2023 and 6/7/2023. Please stop. To submit that records, he also carried us to copy of the order sheet filed along with the bail petition. This discloses that lower court record remained with the original records of the court. Lower court, trial court remained with the high court, and it was returned only between 20 it was returned to the trial court on 28/8/2023. Please stop. The records were summoned at the instance of the applicant in revision in criminal revision number
प्रीवियस वाला जो था विवेक चौधरी वाला देख
criminal revision number
ये
2421 of 2022. List of if other submit that against the order dated 9/7/2020. क्या था कि 9/7 सुप्रीम कोर्ट वाला no such case is order होगा against the event बोला ना हाँ छोटा बाकी ये कौन सा ऑर्डर ये हाई कोर्ट वाला ऑर्डर ये है against the order dated 9/7/2020 passed in CRM 4519 of passed by this court in CRM 4519 of 2020 with CRAN 2671 of 2020 regarding extension of period comma the petitioners referred special leave to appeal within bracket criminal bracket close number 5966 of 2020. Stop. It submits that the petition that the applicant is the driver of the truck from which 391.4540 kgs ganja was recovered, and thus applicant was the person in charge of the vehicle from which the ganja was recovered. Stop. The case of other co-accused stands on entirely different footing, and therefore no parity can be claimed on that basis. Stop. Fresh paragraph. We have carefully considered submissions of learned counsels for the parties. Stop. Fresh paragraph. We find that the bail application of the applicant was rejected. Very recent was rejected. Bail application of the applicant were rejected thrice by this court by order dated 5/6/2022 in CRM 3886 of 2021, order dated 23/2/2023 in CRM within bracket NDPS bracket close 276 of 2023, and order dated 6/7/2023 in CRM within bracket NDPS bracket close number 1067 of 2023. Of perusal of this order proves that all the submissions as is being raised today by learned counsel for the applicant, were considered and rejected by subordinate benches. List of the most recent order rejecting the bail application of the applicant is dated 6/7/2023. List of nothing, no new circumstances or changed circumstances has either been brought to our notice. Has neither been brought to our notice nor argued. Under the circumstances, we do not find it a fit case to. We do not find the present case to be a fit case for grant of bail. Accordingly, the bail application of the applicant is rejected. Fresh para. However, considering the facts and circumstances of the case and the long period facts and circumstances of the case, we expect that the trial shall be concluded by the trial court very expeditiously, preferably within a year. With these observations, the bail application is rejected. Subject to these observations, the bail application is rejected.
কি হলো কি Sure, sir. Reject না? ততক্ষণ হয় না বলে চাট মারা তব জানিয়ে যে ফেরা তো আমি যতক্ষণ কথা না শুনে নি আমরা
আমার নামটা দিয়ে দিন বাংলা আমার নামটা দিয়ে দিন
রিজেক্ট করেছি রিজেক্ট করেছি
বসবে না
আমার কাছে অনেক কম মিস হয় দেখবেন 99
দেখতে পাচ্ছেন মানুষ এসছে কিনা তো আসেনি ফোন দিলাম ওই জন্য
ওদের কাছে মেনশন করবি মেনশন এখন নেবে না
চেষ্টা করে দেখি একবার
না
নাহলে
না
এই হাফটা
আরেকটা বেঞ্চ
হয় না তো ওটা তো এখন সম্ভব হয় না হ্যাঁ কালকে থেকে প্রচুর
ঠিক আছে এখন নিয়ে নি
চলে যা পাঠা আসেনি তো আসেনি তো
পরপুরি করে যাচ্ছে
চলে যাবো
Justice Keshavani, my lord, and just because due to paucity of time, hopefully if your lordship allows my prayer, my lord, because this item number 42 in the other list, my lord, this item ideally should have been item number 43 because of the CRM number. Some my lord, mistake on the part of the department, the matter is not appearing, my lord. If your lordship's direct, I have also inquired the CDs also here, my lord. If your lordship direct, my lord, the matter to be coming in the supplementary list, my lord. This matter ought to have been item number 43 ideally, because item number 421
What is the present item number today?
it's not there in the list. 4213 CRM number, and there was 4211.
You cannot
This
use that. When you sit in the regular bench, you'll consider.
But what-
Let it appear on the next vacation.
my lord, consider
No,
the case that is also here, my lord.
Sorry.
Thank you to all of you. I enjoyed, in fact, I enjoyed along with my esteemed brother. And
Sir, can you take up the
I'm-
microphone?
I am-
Can you take up the- It's hot.
and I have no hesitation to say that your bar is excellent. As I said in my a small speech also, that you possess 6 qualities that I have spoken through a slok, Sanskrit slok. In fact, that is a slok written by Chanakya that I have spoken. Thank you.
I'm grateful, my lord. We are all grateful.
কোনো চান্স
দুটো Mr.
My
Basu,
lord, the difficulty is, my lord, if urgent matters, my lord mentioned, or somebody mentioned, my lord, including mine, that has been gone down.
nothing doing. What can be done?
Civil matters, my lord, will not touch.
Milord, yesterday, Milord, I mentioned
Cannot
one
touch all the
Mandamus
matters.
appeal, Milord, yesterday,
Yeah,
Milord.
civil matters has will not.
Circuit bench matter, only one matter, Milord, Mandamus.
Yesterday, the judgment and order under appeal was passed. Your lordship was kind enough to grant believe it is item number 226. May it be taken up. Mr. Topon Mukherjee is my other side. I will inform you any time convenient to your lordship before rising. 210. Fourth is
My matter is also same.
We cannot make any exception for any of the matters. We will call on the list serially.
Serially.
My lord.
Oh,
Prabhavit circuit ছেড়ে দিন। আপনি এখানকার বেঞ্চে 41
my lord, leave me granted.
My lord.
Milord, I have a
Mr. Basu, come here, take the mentionings. Please, please. I appoint to amicus curiae, please come here, take the mentionings.
Kindly.
Just sit for 5 minutes and see how. No, just sit for 5 minutes, take up the mentionings. Just look behind you. Please look behind you. Mr. Bhattacharya, I request you to look behind you. Once look behind you. Is it possible for a vacation bench? Call on the list, please. 41, I want. Don't make ridiculous prayers, please.
Leave my lord, kindly.
My lord, only the matter.
Leave my lord.
Matter, which is very
চলো।
Hey,
বসবো না।
but kindly don't rise, my lord. Take up some.
No, not possible.
Kindly
We'll
don't
not sit.
rise.
No, we won't
Some
sit in the court.
matters.
This is my petition, my lord. Yes. What is the matter, please? Section 6.
Section 6 with 376D, my lord. In the charge sheet, it was some 2 more sections were added. My lord, my ground for bail, my lord, my ground for bail is, my lord, the prosecution story is doubtful, my lord. There are 4 different versions of the same incident.
What is your age?
Of the alleged incident.
What is your age?
My lord, 24. 24.
What is the age of the victim?
14, my lord.
13 years, 13 years. And
Yes.
My lord, 19 years. My lord, my mistake, my lord. The petitioner's age is 19 years, my lord.
Correct,
19
yes.
years. 19 years. The age of the victim is 14 years, my lord.
What is the discrepancy in the
The
prosecution?
discrepancy in the prosecution story is, my lord. My lord kindly sees my lord kindly takes up the case diary once, and my lord kindly sees the FIR report. My lord, may I hand over, my lord?
What is the discrepancy? Tell us first.
My lord, in the FIR, my lord, it was stated by the de facto complainant that the petitioner was known to the victim, and the other 2 persons who were alleged in the same incident were not known to her. And in the 164 statement, my lord, suddenly a name appears, my lord, and there, my lord, the victim girl has stated that there was some previous love relation between the other accused person who is not the petitioner. And then, my lord, the 164 statement and the FIR, my lord, the description of the incident is different. My second point is, my lord, in the medical report, my lord will see that the doctor was opined that the victim was in full senses during the alleged act. And
How can the doctor opine that?
my lord, as per the victim statement, my lord, it is
That is not
happened.
admissible.
No,
Doctor's reference to victim statement, no.
145 given.
Hymen was ruptured.
160 statement,
My
145.
lord, my contention is, my lord, the petitioner was not even the petitioner was directly implicated in the matter. He was not present.
Let him finish, Mr. Man. Yes. Yes.
It's a heinous offense plot subject to.
My lord, and the most important thing is, my lord, the identity of the person who allegedly ravished her, that is under the main question. That is apparent from the FIR and the 164 statement, my lord.
Sufficient to dispel the presumption under section 6. Sorry. Learned counsel for the petitioner contends that there are several discrepancies in the prosecution case as regards the identity of the offenders. Full stop, next para. However, on a perusal of the
case diary, and upon hearing submissions of learned counsel for the petitioner as well as the state, comma, we are of the opinion that the strong presumption under under the POXO Act cannot be diluted in the facts of the case for the purpose of bail. Full stop. Accordingly, CRM DB 4200 of 2023 is dismissed.
I'm obliged.
Sorry.
Obliged.
Item number 42.
I
Yes.
appear for the state.
None appears for the petitioner at the time of call. Let the matter be listed in due course after the vacation. 42.
Obliged.
Thank
Hello.
আজকে একটু বেশি হচ্ছে।
Item number 43.
43, my lord, I am for the petitioner.
I appear for the state.
Yes.
Charges under section 464,
40.
467, 468,
Use the mic, use the mic.
474, 475 IPC and 14 AM, 40 C of Foreigners Act.
Yes.
This is second time, my lord,
Foreigners Act.
Foreigners Act.
আচ্ছা, yes.
This is second time, my lord, moving this matter
When
before this
rejected?
honorable
When rejected.
when
Last-
6th February, long ago. That point of time, no, many other co-accused persons were in jail. However, I am languishing behind the bars for 533 days, more than 1.5 years.
Organized racket.
No, no,
That is the finding of the court.
I'm coming to that. I'm coming to that.
And Lord,
I'm coming to that.
If you go out, you will do the same thing.
533 3 days.
Hmm.
Out of 15 co-accused persons, 14 are of bail, including the principal accused is on bail.
Out of
no.
15,
how many are on bail?
14. Only one I am languishing. We having no point. My lord, I am coming to that.
আমাকে বলো না কিছু না
You did not point.
Same thing.
You did not point this out to the coordinator.
Yes. The learned district judge only point of rejection was that there is a rejection from the High Court. Nothing else. And verbally he has said that we get it from the High Court. That is the point, nothing else, my lord. And 35 witnesses to be examined. And after framing of charges, as many as 9 dates has gone by. And his prosecution has palpably failed to produce any witness. And it is evident from the order sheet I have annexed.
the learning.
And finally, এক minute. Petitioner is only 14 years of age. 14 years of
Out
age.
of 15, 14 are out.
Yes, I am on the same thing.
14 granted bail.
Yes.
They jumped the condition. They went to the Bangladesh.
No.
Yes.
No.
You kindly see the memo I've handed over. 14
No,
persons
14 are
and 8 persons are absconding, not attending in trial.
No. That is not reflecting. My lord, I have annexed the order copy. Everything is appearing.
We'll direct a report to be filed by the state.
No.
My lord.
I shall abide by all conditions. I shall abide by all
Also, the
conditions.
petitioner submits that 14 out of the 15 co-accused persons with the petitioner have been enlarged on bail. Full stop. Hence, comma, on the ground of parity, comma, the petitioner seeks bail. Full stop. Next para, learned counsel for the state points out that on February 6, 2023, comma, the petitioner's prayer for bail was rejected. Full stop. More importantly, comma, it is submitted, comma, the persons who have been enlarged on bail have
Out of them, 8 persons are absconding. They went to the Bangladesh.
No, my lord.
Yes.
either
This is the order copy, my lord. This is wrong submission.
have either jumped.
I stand corrected. My lord,
If you stand corrected, don't argue. Let us. You stand corrected. So let
My
us
lord,
complete the
kindly
sentence.
seize the order copy. Nothing is reflected in the order. I have annexed. That is why.
Chalan.
Since framing of charges, everyone is appearing. Where from he has got, I have no idea, my lord.
সব কি আমাকে করতে হবে না?
More importantly, it is submitted the persons who have been enlarged.
On record.
আরে দাঁড়ান না
Absconded or jumped bail. Full stop. Next para. Although such contention is disputed by the petitioner, comma, in order to bring proper picture before the court, comma, the state is directed to file a brief report on the next returnable date with an advance copy to the learned advocate for the petitioner, indicating the circumstances as argued in court today and reflected above. Full stop. The petitioner shall be entitled to controvert the contents of the same by way of a short rejoinder. Full stop. The matter shall be listed before the concerned coordinate bench on November 8, 2023. 8th November. Mr. Banerjee, please ensure that a
My
copy is
lord,
given to them
my-
previously so that they can controvert.
My lord. But 8th November, next.
8th November during vacation,
Lord, kindly send it to
8th November.
regular bench.
regular bench.
Regular
Kindly send it
তাহলে
to
8th November না করে না ওই জায়গাটা করে দিন before on 8th November না করে
16th November.
on November 16, 2020.
Great.
Obliged, your lordship.
Thank you. Next.
8 তারিখে দিয়ে দেবেন কিন্তু রিপোর্টটা ওর হাতে দিয়ে দিতে হবে।
On
Article
আপনার
40
ওটা দিয়ে
44 who is appearing?
My lord.
Yes.
I appeal for the state, your lordship.
Yes.
My lord, I am in custody for just about 14 days short of 1 year. Now, things go like that.
Please use the microphone.
The daughter of the complainant,
Yes.
she was a college going student. I am a man of that locality. I tried to woo her, but she refused to do this. So I went over to their house and I said that I'll marry I'll marry the girl. I wanted to marry, but they were not inclined. Now, on 13th of November last year, when the husband and wife, the complainant and his wife, they had gone out and the daughter was alone in the house. A person came and the daughter, that person left after 15 minutes. The daughter was found strangulated with a onna. Now, my lord, when this was rejected last time way back in July, I did not have the papers.
You got the city?
Yes, 207 papers to assist your lordship. My lord, the prosecution case rests on the 164 of the neighbor who saw that person. But I have gone through that statement. He does not identify. He says, একটা ছেলে এলো এবং 15 মিনিট থাকলো তারপরে চলে গেল. This is the only statement which implicates this. They are seek to implicate on the basis of this statement. Your lordship sees Ganesh Haldar. Nowhere in the 164 this person has identified me or named me, and I was not even placed.
What is the change of circumstances after
My lord,
July 3rd?
I was, as I said, my lord, I was not in a position because these copies had not been supplied. Now, with the supply of the copy, I could not address the revision bench because 207 had not been.
You have presented the place of occurrence, that is a finding.
That is what he said on the basis of the statement of Ganesh Haldar. Now I see that the statement of Ganesh Haldar, for once, if your lordship takes up once, this is the only statement.
What is the page
I've
number?
given the one statement of Ganesh Haldar.
It does
Page,
not
page,
identify
page
me or
80, page
name me
80,
even.
Page 80.
page 80. I've given, let's say, folded this, lordship.
করে যাচ্ছে।
He is the neighbor. You go to the 164 statement.
And I was not placed in TI parity.
দেখলে চিনতে পারবে, he was not named.
Not
Actually, but let me submit. One, he stated that I can identify the person concerned if he is present before me.
That will be determined in the TI parity.
That is lordship.
and no TI parade was held. And
But PM report, lordship, come to the 78. There is a strangulation.
strangulation by Onna.
Strangulation?
By homicide in nature.
And my lord,
Homicide
one
in
more
nature.
thing, your
Or
lordship.
role is in question.
After 2 months, this 164 was recorded. 3rd of January, incident is of 13th of November.
What is the stage? I mean, the charges have been framed.
My
and all.
lord, charge, date of framing of charge,
Charge still not framed.
18/12/23.
Not charge, not even framed.
Not strong. Homicidal year. It will be too early to release you on bail.
No, 1 year already. And on, my lord, kindly sees the evidence. He says, ছেলে একটা এসেছিল তাকে দেখলে চিনতে পারবো, but not placed in TI parade. The only thing that I wanted to marry that girl against the wish of the parents. That is reflected in the FIR itself.
Yes,
Had
what
the
do you say?
Axe to grind, that is reflected in
Sir,
the
what do you say?
My lord, one thing is that according to the 164.
He was not named by anybody.
He not named anybody, but 164 statement, and only the person concerned 164 has seen the one person seems to be that person is
Nothing to link him with that.
link that. Not only that, the scooty also, man has fair submissions before lordship. They have first of all seen the scooty. That scooty was not one identified, but he's seen
Anything to link the scooty with him? Nothing on record.
that
Scooty even not identified.
the scooty, let me finish. That scooty is not my lord seized, but he has seen the
There's nothing
scooty.
to link this person with that. Just because he had a relation.
But just once, I cannot, my lord, go to beyond the 164 statement. But one consideration is that because the homicidal nature is strangulation, that is in there.
Homicide strangulation is apparent from the
Nah, but
records.
you see-
Yes, subject to proof. Yes.
Subsequent development you see in the 164 statement
Yes.
that he has seen what is the scenario of the deceased, how he is lying in the bedroom. That will go to the last portions of this.
Nobody, there is no 164 statement, nothing to indicate that this person was named as to be presented.
Only I am showing only the for which I am only showing the 164 statement, not any other 164 statement. That is the material to him. But only 164 statement is material to him. I am showing.
Learned counsel, we are granting bill. Learned counsel for the petitioner contents that the petitioner is in custody almost for a year. That apart, the petitioner was never named by any of the accused persons to be connected with the
Witness. My lord said accused person, not named by the witness.
named by any of the witnesses to have been connected with the alleged offense. Next para. It is further submitted that the only premise of incriminating the petitioner is apparently the petitioner's previous relationship with the deceased, which has no nexus.
Don't take it. I missed. Pause for a moment. Come to the
Which
page
has no nexus
12
with the
and
crime.
13. Page 12 and 13. I just now. Page 12 and 13.
Yes.
That's the statement. Just one 161 statement, one 162 statement. Well, for your convenience, Lord.
Ganesh Haldar was present there.
Ganesh Haldar's 164.
160. Let me finish. Two statement, one 161 statement, page number 12 and 30. Another is 164 statement that has to. But just to for your convenience, Lordship, go to the.
Yes, Mr. There is nothing.
Because I am for your convenience, Lordship. It is my duty to show you, Lordship.
Circumstantial. Direct
12 and 30 page. There he took the name.
Investigation complete হয়ে গেছে.
There he took the name, but thereafter subsequently developed in the 164 statement.
Learned counsel for the state opposes the prayer for bail and points out that in the statement under section 164 CRPC of one Ganesh Haldar, the petitioner has been named.
No, has not been named. 164 not named.
164 he never named, but 161 statement he took the name. That is why showing you that once.
Who took his name?
This Ganesh Haldar. If you go to page number 12 and 13.
My lord, may I clarify the position? My lord, when Ganesh Haldar was examined by police or police recorded
Last sentence যেটা বললাম সেটা কেটে রাখুন আমি বলছি.
When police took the statement, Ganesh Haldar purportedly said that the name. But when Ganesh was presented before the magistrate for his 164, Ganesh did not name anybody, did not identify anybody. And I was not placed in TI.
Learned counsel for the state opposes the prayer for bail and submits that the petitioner's name was taken by one Ganesh Haldar. Next para. However, we find from the records that in none of the statements under section 164 of the CRPC, the petitioner was named as such, we do not find any direct nexus between the petitioner and the alleged crime for the purpose of consideration of the prayer for bail. Accordingly, CRM DB 4216 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner shall not leave the territorial jurisdiction of the trial court during the entire period of trial. The petitioner, further, shall attend each and every date of trial and shall not make any inducement, threat or promise to any person being acquainted with the facts of the case so as to dissuade such person from disclosing the relevant facts to any police officer or to the court and or tamper with evidence in any manner. যেখানটা বলেছি না যে লাইনটা যেখানে বললাম shall released on bail, they are granting bail to the petitioner on condition the petitioner furnishes a bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction
of the ACJM Ranaghat.
Of the learned ACJM Ranaghat. Yes, what other
condition? In default, in presence in the trial court, automatically it can cancel the bail.
In default of compliance of any of the above conditions, the bail granted to the petitioner shall stand automatically vacated. Thank you. Next. একটু এদিক ওদিক হবে আপনারা ইউজুয়াল অর্ডার একটা দেখে নিয়ে করে দেবেন হ্যাঁ যদি অসুবিধা হয় জিজ্ঞেস করুন লর্ডশিপ yes
may I permitted to mention
item record
item 42
45.
45
For the
years.
petitioner, my lord.
Yes.
So the petitioner is in custody for almost 749 days. Lord, this is my renewal, my lord. At best, my lord, the allegation against this petitioner would be, my lord, 411. Since, my lord, the prosecution case is that Lord, the driver of a vehicle, lorry, Lord, he came with fish from Lord Andhra Pradesh to Ranaghat.
You are the driver.
The complainant. The complainant is a driver of a truck who carried fish from Andhra Pradesh and delivered it to Ranaghat. And thereafter, he collected a sum of rupees 60 lakhs, and this was put to Lord in the back of the lorry. When they were coming back after collecting the money, Lord, a Scorpio car, Lord, intervened. 5-6 persons came out from the Scorpio car, and they have taken Lord the money, robbed the money. Other accused persons were identified, but I was not identified. The only complicity is certain amount was recovered from me. Lord, that is the reason, Lord, I say 390.
Currency notes were traced to you.
Lord, sorry.
Certain amount was found from you, means?
Allegedly, Lord, the recovery, certain amount was recovered and from my possession, but I was not identified because the complainant initially said
The amount was traced to the amount lost. The amount which was taken.
they say, Lord, it is part of the amount. Lord, I say it is.
Well,
not
Mr.
this-
Ahmed, let us hear this state. Yes.
My Lord, may I just,
Yes.
just one word, Lord.
What else?
This is my business amount, and I was no way connected with these persons. Lord,
You are in what business?
Lord, I have my own business of fishing, and that is the reason I have been nabbed into this case. I'm a competitor of the person, Lord, from whom it was delivered, except recovery, because I was also put to Lord in the TI parade. The
Could not identify.
the complainant and his khalashi both could not identify me. I was not present in the place of occurrence.
My lord, may I,
At best, 411 and the punishment is 3 years.
May I
I'm in
submit, my
custody
lord?
for almost 2
Yes.
years.
my lord, first of all, the petitioner before your lordship, he is the day labor or day worker of the fish center wherefrom the everything was looted, my lord. My lord, he is the conspirator, supplied the information that such and such number truck is going with 60 lakhs of rupees. He was not present at the spot, admittedly, he was not. Please, Mr. Ahmed,
I
please.
didn't say anything.
He was not present at the spot. So, my lord, question of TI parade doesn't arise at all. And my lord, 3 lakhs 50 out of 60 lakhs, 3 lakhs 50,000 was recovered from his possession.
You could trace out the currency notes, or how did you look at that?
My lord, cash,
Amount was with him. Might have been
Yes.
from some other source also.
that may be, my lord, that I cannot say because the numbering was not there.
Naturally, it was not there.
Yes.
When you take cash for fish,
Yes, yes. My lord, kindly see the Caesar list for once, my lord. That is at page 24. Page 24.
Lord, others were identified, so 395, 397 is against them. And Lord, as indicated by my London
And my lord,
friend,
out of
24, what is there?
my lord, that is the Caesar list. The cash of 3 lakhs 50,000 was recovered from him.
How could you connect the cash to him, to that robbery?
That is my lord, very difficult. My
It
lord.
will be, maybe may come out in the investigation.
My lord,
but
a
the
heavy
charge has
amount,
been filed.
a heavy amount, my lord. Heavy amount. And not only that, my lord, out of 21 witnesses, my lord, 3 have been examined in the meantime. And next date is fixed on,
He's on a lighter footing than the others, Mr.
my lord, that is admitted position.
Let us grant him bail. He will attend the trial on his own.
Kindly give some stringent condition, my lord. If your lordship decides to
In
grant,
the court, even when the date is not there.
my lord,
He will attend court even when there is no date of his Learned counsel, the petitioner submits that the petitioner has been incriminated with in connection with an alleged burglary. So it is submitted that the only factor which goes against the petitioner apparently is recovery of an amount from the petitioner, which according to the petitioner he earned from his own business. Next para, it is further argued that the petitioner was never identified by the driver or the helper of the vehicle, which suffered the alleged offense. Full stop. Next para. Learned counsel for the state opposes the prayer for bail and submits that a substantial amount of rupees 3,50,000 was recovered from the petitioner, comma, who is a day labor in the fish center, comma, where the incident took place. Full stop. Next para. It is further submitted that the trial is ongoing and bail ought not to be granted at this stage. Full stop. Next para. We find from the arguments and counter arguments that the chain of events does not directly relate to the petitioner palpably so as to refuse him bail, comma, particularly since the petitioner is already in custody for about
49 days.
749 days. Full stop. Next para. Hence, comma, CRM DB 4217 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner shall furnish bond of exactly আগেরটা যা হলো তাই 10,000 to sureties like amount each to the satisfaction of the
CGM Barashat
learned CGM Barashat. বাকিটা कोई attend trial যা যাবে।
Deeply obliged.
Thank you.
Item number 46.
Item number 46, Lord, I appear
Yes.
on behalf of the petitioner. my lord.
Yes.
Allegation against me is the alleged
for the state
alleged violation under section 489, counterfeiting the currency notes. One term, my lord, is 80,000. Now, my lord, when the FIR was, my lord, lodged, my name was not there.
That explains your presence.
Huh?
That explains your presence. The money explains your presence.
Nothing has
Your
been-
presence. Yes. What then?
FIR, when was lodged, my name is not there. Now, my lord, on the basis of a statement of a co-accused, my lord, my name was, my lord, included, my lord, in the charge sheet. Now, my lord, nothing has been recovered, nothing has been mentioned against me. Now, my lord, without a leave, my lord, a supplementary prayer for supplementary charge sheet has been made. Lordship knows a leave normally is required. No leave has been granted, prepared. Nothing, no material, save except a statement under section 161 before the police authority, my lord, which is inadmissible. I am in custody, my lord, since 19th May. 19th May 2023. And one more important thing I tell you, Lordship, why I am in custody. I filed an application for discharge because nothing is against me. On the same, after I filed the discharge petition, they filed an application for jail custody, custodial interrogation, which was allowed. My prayer was rejected. Nothing, blood, best possible evidence, blood, what they could say, blood, kindly come to blood page 26. Nothing against me.
That is also recorded after.
Kindly come to page 26, blood. The paragraphs. All on a sudden, page 26, Lordship sees, blood.
All on a sudden?
Well, all on a sudden, I tell you, Lordship, the last paragraph. Suamoto, my lord, the case was initiated. Kindly see, my lord, he visited the SI. He conducted the raid. My name is not there. One term has been mentioned in the previous page. Kindly come to last paragraph once.
Yes.
During the investigation of the case and consider
You're not opposing.
Don't waste the time, Lordship. Actually, he was arrested on the basis of co-accused statement. Nothing has been in positions. He is lucky enough to flee away.
Pardon?
He's lucky enough to flee away when
He.
raid was made.
So let him flee also in this. Let it be legal now.
Always I'm telling him don't waste the time.
Very well. Thank you so much, Mr. Dutta. Learned counsel for the petitioner contends that the petitioner has been indicted on the basis of the statement of a co-accused person, and there is nothing against the petitioner in the charge sheet. Full stop. Next para. Learned counsel for the state. Formally, you are opposing, Mr. Dutta?
No.
You are not opposing. Fair enough. Learned counsel for the state, comma, in his usual fairness, comma, admits to the extent that the petitioner has been indicted on the basis of the statement of a co-accused person.
Conditions should be imposed.
Pardon?
Conditions should be imposed.
Yes, yes, definitely. So, however, comma, learned counsel for the state submits, sorry, APP. Learned counsel for the state গুলো একটু APP করে দেবেন। হ্যাঁ, APP. Learned APP submits that stringent conditions may be imposed if bail is granted to the petitioner. Full stop কি বলছেন? আচ্ছা। Full stop. Next part, we find upon hearing learned counsel for the parties that a sufficient case for grant of benefit of bail has been made out by the petitioner. Full stop. Moreover, comma, since none of the allegedly fake currencies have been recovered from the petitioner, we are inclined to grant bail. Right? So accordingly, CRM DB number 4218 of 2023 is allowed, granting bail to the petitioner. Exactly same.
ACJM Kandi. Milord, ACJM Kandi, I'm told, Milord.
ACJM Kandi, ACJM Kandi. So, to the satisfaction of.
I'm grateful.
Thank you.
Item number 47.
Item number 47, my lord, I am for the petition.
Yes.
Lord, 300 to 120B. Lord, I am in 300 to 120B. Lord, this is the first time. Lord, I am in custody more than 10 months.
10 months?
10 months.
Without 10
Lord,
years.
charge sheet submitted. So for my instruction,
302 is serious. Gravity is serious.
there is no eyewitness. There are four, Lord, 164 witnesses. Lord, out of which, Lord, minimum two witnesses, Lord, stated that they are out of Bengal. And another, Lord, the de facto complainant who lodged this complaint. Lordship, kindly see the complaint annexure P1. The complaint, Lord, postulates that on 22nd January 2023, Lord, one Taslima Bibi called her father at 5 p.m. Thereafter, that is the Lord, victim. Thereafter, Lord, the victim left the house with his motorcycle. He did not come back. On the next day, the dead body was found. Only, Lord, this is the Lord. Lord, charge sheet submitted. Charge has.
So no eyewitness, and two of the witnesses.
No, there is no eyewitness.
And two of the witnesses said that they were out of that area at
that point, relevant point of time on the day of incident.
What is the period of custody?
Malad 10 months.
10 months.
23rd Malad January, I have been arrested.
So let us hear the state.
Malad.
Yes.
My lord, what happened, my lord? Before going to the merits of the case, my lord, I am, my lord, submitting 2 points. The petitioner before your lordship, he had an illicit relation with the daughter of the complainant. And, my lord, the deceased had an illicit relation with the another lady, My lord, the deceased, he had an illicit relation with a lady of the area.
Right.
And the petitioner before your lordship,
he also had an illicit relation with the deceased.
With another, with another lady.
19 years only, my lord.
With another lady of that locality. My lord, the deceased protested to that. And he tried to, my lord, these persons from the village. This is the background, my lord. My lord, so many 160 statements of the witnesses who saw the persons, one of the accused, that is the lady, as my lord, along with the deceased, and the petitioner before your lordship,
not accused person, the deceased.
This is deceased. The lady was deceased. This is the accused person. He had the
only the petitioner had a relationship with the daughter of the deceased.
No, not the daughter. Another lady of the village.
Yes. So how is that connected?
My lord, the deceased protested to that. That in our locality this should not be done. That is the reason.
For that reason, he killed the.
Yes. Yes, my lord. Kindly see the statements. There are so many 164 statements.
Nobody saw him there or coming out from that.
Yes. Everything is there. Everything is there.
Illicit relations were not related. Be interested in, but show something to connect this person with.
My lord. Finally come to first, my lord, page 22 and 23. Those are the 161.
খুব ভালো সিডি দেয়, ওকে দিয়ে সিডি গুলো দেন। প্রীতম তুমি সিডি গুলো দেবে।
22. My lord, page 22 and 23. My lord, page 23 is the statement of one of the eyewitnesses.
They have stated that is their perception, Mr. Ganguly. Just see the statement.
My lord, kindly come to page 23. Page 23, my lord. Page 23.
Specific allegation, my lord.
22, 23, 24.
Page 24 also.
24, 22, 23, 24.
And then, my lord,
The murder weapon was a bamboo stick or something.
yes, bamboo sticks, rods.
That is the PM report.
My lord, PM report is at page 312. 312. That is due to injuries, antemortem and homicidal.
That is postmortem report injuries.
বলে দিচ্ছি হ্যাঁ হ্যাঁ and my lord 164 statements categorically my lord implicate this petitioner. And the wearing apparels, mobile phone were seized at the behest of this petitioner, my lord, of the deceased.
From his residence.
No, from a abandoned place.
So how is
Wearing
it correct?
used as well as the personal belongings.
So how is he connected with that? Those
As per his written statement, everything was recovered. As per his written statement, that is at page 206, 202. And reconstruction of crime was done. That is at page 201. Please, let me submit, please. Let me submit. Reconstruction of crime was done. That is at page 201.
How to reconstruct করেছে?
And my lord, the co-accused Mursid Sheikh, his prayer was turned down on 28th of July 23 by this honorable court, coordinating bench of this honorable court. And my lord, Muftara Bibi, her prayer was turned down by the coordinating bench on 12th of October.
So they were on an equal footing or
Yes,
or even
yes, yes.
Yeah, what do you say to
My
this?
submission is that, my lord, there is no IOU.
All of them are together.
Eyewitness নেই কিন্তু circumstantial যথেষ্ট রয়েছে বলে
There is no eyewitness, my lord, only, my lord, on the basis of the circumstantial evidence.
Submit that there was a no.
But even
My lord, everybody saw them with weapons. হ্যাঁ বলুন স্যার বলুন
Learned advocate for the petitioner submit that there is no eyewitness and no incriminating material to connect the accused person with the alleged offense. ঠিক আছে? And hence, and the present petitioner is in custody since
My lord, 10 months.
the present petitioner has been
Since
languishing
24th
in
of
jail
January.
custody for 10 months and hence the petitioner should be released on bail. Stopped. Learned PP, learned APP. Learned APP vehemently opposed.
Mr. Ganguly or
my lord
You're also APP?
yes
Learned APP, such and such, learned APP vehemently opposed the prayer for bail. He submits that from the disclosure statement made by the accused person, some incriminating materials was recovered and the accused person who stand on the same footing, the prayer for bail of the accused person, co-accused person who stand on the same footing has been turned down by a coordinate bench on
my lord one on 20th of July and another on 12th of October.
On 12th of October 2023. Stopped. Had the learned advocate peruse the CD and other materials. Stopped. So although there is no direct evidence, but the case is based on circumstantial evidence and some incriminating materials has been, and there are some materials against the present accused persons. Stopped. Considering this aspect, we are of the view that it is not a fit case to grant bail to the.
I'm grateful, my lord.
Lord, charge sheet submitted,
grateful.
charge has
And
not
hence the
yet
prayer
been
for
framed, my
bail
lord.
is thus turned down.
How many witnesses, Mr. Ganguly? Approximately.
My lord,
my lord,
there are
my lord
at
hardly
least 38.
No, no, no,
48
no.
or 48 witnesses.
No, 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 no.
I am not-
My lord, hardly 21, 22 witnesses would be examined. And my lord, charge sheet has been submitted only in the month of April. This is a case of January of this year.
Early stage. Very, yes. Next.
Item number 48.
সিডি গুলো তুমি দিও, উনি ফাইল গুলো দেবেন, তুমি সিডি গুলো, মোটা হলে তুমি দেবে, রোগা হলে উনি দেবে।
May it please your lordship.
Yes, please.
Well, this is a case under section 376 DA, 384 120B of the Indian Penal Code, read with section 6 of the Protection of Children from Sexual Offences Act. Well, the crux relates to rupees 500. This girl, my lord, will kindly come to the FIR.
Your age, her age,
13 years. My lord, this,
your age,
my age is 30 years.
30.
30, yes.
She,
She is 13, 1-3.
30 and 13.
Yes.
Acha, very well, yes. 500 rupees, yes.
My lord, what happened? Well, we'll kindly see the FIR once. What happened? This girl, she was stealing, she stole something from a particular shop. She admittedly is the daughter of a beggar. My lord, I am not onto that. Admittedly, according to the first information report, she is the daughter of a beggar. Now, she was stealing something from a shop. She was caught. I was known to him, known to her. She called me up. This all happened in the month of October 2022. October or somewhere, sometimes around October 2022. I paid rupees 500 to the shopkeeper, and my lord rescued her from that situation. This is there in the FIR. Then, my lord, I demanded my 500 rupees back from her and her mother, which was difficult for her to pay. That I understand. Now, the recourse she had taken is this. In the month of March 2023, this FIR has been lodged, saying that I have allured her that I will give her a job in a parlor and have taken her to a flat where I have, I had, my lord, committed with her and everything. And this is the crux of the matter. Rupees 500 is the issue. Two other accused persons in whose flat I have taken, have been granted bail. The flat has been released. Another person, allegedly, he has also raped. That person has also been released. I am the only person in custody right now. One is absconding. Four persons.
What about what do you say regarding the co-accused having been released?
Kindly turn to page 62, 164 statement.
No, what about the co-accused persons being released on bail?
Identified, my lord, in TI parent, my lord. Kindly see.
They were also identified.
Yes. My lord,
We
kindly.
are asking you a specific question. Please answer that first. We will come to whatever you point out. What about the other co-accused persons? They were on a similar footing as this petitioner. That is the only question we are asking you. The other circumstances are there.
My lord, kindly peruse 164 statement of
We are convinced of the crime. Suppose let us we are convinced of the crime. What do you say regarding the other co-accused persons being granted bail? Don't you understand the ground of parity you are moving a criminal material for the state? If they are on an equal footing, others have been granted bail, why should they be refused? Article 14 is violated. We are only on that. I am not asking you any other question. Suppose we are convinced of the crime, even then. How can we get over the co-accused person's bail?
Rocky Mondal was arrested on 27/3. The Mansur Ali was arrested on 27/3.
Parity on exactly. Whether they are on equal footing, that is the only thing you have to.
তাহলে কোন জায়গাটা বলে দিন না
তুমি বলো মানে প্যারিটি নেই বলো
আচ্ছা ভিখারির মেয়ে বলে
No.
তুমি বললে না এভিডেন্স রাখো
Have you annexed those bail orders?
My lord, no, I have those bail orders.
Prima facie we are against you.
I understand, my lord.
Here, my lord,
My lord, the section.
here, my lord, only Rocky Mondal is the petitioner. Rocky Mondal is also is the
We are not
petitioner.
interested in Rocky or Rocky 2 or Rocky 3 or Stallone or something like that. We are only interested if he is on an equal footing with the others.
Not
You are telling you that you are prima facie convinced of the crime.
not on the same footing, my lord.
Why not? Tell us that. Get your rejection order.
For that reason, my lord, I wanted to submit before your lordship.
What is the difference in
Kindly see the 164 statement of the victim girl.
what should he find from here?
That
I have seen it, yes. So
name of the Rocky Mondal will appear. Who is the principal accused, my lord?
Shubhankar is Rocky.
No, my lord.
No. Rocky is the principal accused, my lord.
What's so?
Kindly see.
Rocky is the person who paid the 500 rupees, my lord, and who demanded the 500 rupees.
And main allegation against the Rocky Mondal, my lord, the petitioner,
The gang rape allegation is there.
before your lordship.
দেখিনি আমরাই দেখি।
And number 3, Shubhankar Mondal, he is the flat owner. And in the TI parade, Mansur Ali was also identified.
Really was identified.
Yes, in
Then-
TI parade.
Mansur Ali has got bail.
Yes, yes. Mansur Ali has got bail.
Mansur Ali got bail.
You have been appointed by the accused person of the state.
Mansur Ali bail পেয়েছে না? হ্যাঁ, yes.
Tell me.
আছে।
Mansur Ali কোথায়?
Bail পেয়ে গেছে, স্যার।
কোথায়?
আছে, জজ অর্ডার আছে। আমি মিথ্যা কথা জজের সামনে দাঁড়িয়ে বলবো না, চিন্তা করুন।
Passover of 10 minutes will come back. Please let him argue, but he should argue. But please say.
ঠিক আছে।
We are passing over for 5 minutes.
ঠিক আছে। এইটা দেখে নিস।
এটা একটু পাস ওভার করে রেখে দাও।
আমাকে
দেখে নাও, দেখে
দিচ্ছি।
দশ মিনিট বাদে আসুক ঘুরে স্টেট দেখে নি।
Item number 49.
My lord, I am for the petitioner.
Sir, I'm been instructed to appear on behalf of the
My lord,
Not ready?
de facto company.
Oh, de facto.
my lord, I am for the petitioner.
Yes.
My lord, petitioner is in, my lord, kind.
Mr. Banerjee is there. How can you expect that he will not disturb?
No, Lord, I'm sorry.
He's there to disturb, but you have to overcome that. That
My
is
lord, petitioner is in custody for 300 days. Petitioner renews his prayer.
assisting the court, so you don't disturb him. Yes, you submit first, Mr.
No,
Disclose your difference, then it bail.
last rejected on 28th August, that's all.
My lord, petitioner renews his prayer for bail. My lord, case was initially started.
He is right. Mr. Banerjee is right for a change because 28th August refused. What is the change circumstance in the meantime?
My lord, only
the judges have changed.
no, my lord, only detention.
Yes, what is your case?
My lord's case was initially started under section 326, 307. Subsequently, 302 has been added.
There is the best ground for bail.
My lord, other co-accused person from whom recovery has been made, they are on bail, my lord.
Persons were granted bail before your rejection or after? Have you checked it? Before.
My lord, only thing is that kindly see.
Where is the refusal order? Rejection order has been
Yes,
annexed.
my lord, I have annexed.
This Honorable Supreme Court also rejected the prayer for bail.
Anticipatory. Oh. Thereafter, he was absconding. Lordship, kindly see. That is the observation of this
My
honorable.
lord, petitioner has
What is it?
absconding for 7 months. Now,
Oh, you have to ask for. Then,
Absconding.
sorry.
And
thereafter, my lord, the petitioner voluntarily surrendered.
hit on by iron rod, where the person died, victim died. That is the 164.
Learned counsel. No, we are recording your opposition. Learned counsel for the petitioner contends that co-accused persons standing on similar footing have been enlarged on bail and as such renews his prayer for bail. Push up next para. Learned counsel for the de facto complainant vehemently opposes the prayer for bail. Push up. Learned counsel for the state hands over a copy of an order dated August 28, 2023, from which it is seen that the petitioner's similar application for bail was rejected on such date by a coordinate bench. Push up that apart, comma, the petitioner, the allegations against the petitioner are grave in nature. Push up, upon a consideration of the materials, comma, we are convinced that even on the date when the petitioner's application for bail was refused, that is on August 28, 2023, comma, the fact remained that other co-accused persons had been enlarged on bail, comma, which was considered by the coordinate bench while refusing the bail of the petitioner on several cogent grounds. First up, we are of the opinion that nothing has happened subsequently to alter such view of the coordinate bench. Full stop. Accordingly, CRM DB 4221 of 2023 is dismissed.
I'm obliged to your lordship.
Grateful.
Lord, I tender my apology, my lord, because I'm not disturbing.
You have to start with the apology, Mr. Banerjee, because in every matter we will do this.
No, no, no.
So start, I am apologizing and then you are.
I'm not disturbing element. Don't give me that ornaments, my lord.
এটা রেখে দিন, হ্যাঁ এটা একবার রেফার করছি, হ্যাঁ ঠিক।
A copy of the order be kept.
Yes, we are keeping it on record or refer to it.
Obliged to.
Yes.
কেন এটা কার?
Item number 50.
গান্ধী।
Item number 50, I have for
I appear for
my
the
lord.
state.
My lord, case is under section 302, 201, 120B of the Indian Penal Code. My lord, three other co-accused persons are on bail. Allegations against the petitioners that they called the victim deceased over phone. But my lord, kindly, yes, my lord, that is the 164. Kindly see the seizure list. There is no recovery of mobile phone and no call details record is there, my lord. Cases of circumstantial evidences. Three other co-accused persons are on bail, my lord.
When last rejected?
My last two rejected on
13th of March.
Rejected on
9th June
9th of June
2023.
2023.
What happened in the meantime? Why do you file so soon? I mean, only in June it has been rejected. Where is the rejection order you handed over?
Yes, my lord.
Yes,
I have annexed.
Annexed.
Yes, my lord.
Which page? Oh, achha, yes, you have got it.
হ্যাঁ তার আগে হয়েছে 24/2/2024
And 20th April 2023 rejected.
কি?
And earlier, my lord, 12th of October. So last rejection 12th of October. Sarjina.
So, what is
No,
the page
that
number
is
of
the
your
12th.
rejection? What is the page number of your rejection?
Sarjina will be another accused.
No, Sarjina Bibi, that was cancellation filed by the de facto complainant, and that not cancelled by the.
What is the rejection order?
Yes, my lord. Noise.
Mr. Banerjee, you have got a copy of the rejection order?
Yes, yes.
Yes, my lord. I have annexed.
But,
Page number 12, my lord.
9th of 12. 8th of Joshua. Witness court of That's frame হয়েছে না?
চার্জ ফেল 4/4/2023
My lord, page number 15 of my petition.
Is commit হয়ে গেছে?
You did not point out before the court at that point of time that the co-accused have
But
been
charge
released.
has been framed on 4th of April 2020.
Mr. Banerjee, other co-accused persons have been released on bail.
Three other co-accused persons have been.
That is not the two persons who called the victim, and Lord, thereafter the body was found from a pond.
Yes. He
And
also called the
and
victim.
Lord, if your lordship kindly see every 164 statements, both the persons named appear. Names are appear.
My lord, kindly
85,
see
86,
every 164 statement of
88,
bail level,
89.
co-accused persons have been
And
also been named.
Akbar Sheikh has been given bail.
Akbar to etai.
Yes, my lord. Kindly see the 164 statement. Three
bail page was?
three other co-accused persons
No,
who
no,
have
no,
been
no.
granted bail. They also
No,
been
no,
named
no,
with the.
not on parity.
No, parity
They
is
are
not
not the
there.
same footings.
My lord is asking Akbar has been given bail. He was saying Akbar has been
No,
given
my
petitioner number 1 here.
No, no, my lord. That, sorry, my lord.
Akbar is Sohidul. You are Akbar and Sohidul.
Yes, my lord. I'm Akbar.
And
Don't read it,
every
sir.
164 statements, lordship kindly consider.
Page.
85, 86, 87, 88, 89, 90.
No, what about the other co-accused persons who were granted bail?
But they were because the seizure was made on the leading statement, and from there nothing has been recovered.
From
Nothing
these
is-
persons?
Yes, these persons called, and the mobile phone seized. Your lordship kindly see the seizure list. Seizure list, your lordship will find page 43 and 62. And CDR report, your lordship will find page 41. The CDR, the over phone, their conversation between the victim and the petitioner. CDR 41,
Sorry,
46.
learned counsel for the petitioner contends that co-accused persons on the same footing as the petitioners have been granted bail. As such, on the ground of parity, the petitioners also seek bail. For the next para, learned counsel for the state opposes the prayer and submits that the other co-accused persons who were enlarged on bail were on a different footing inasmuch as the allegation against them was that they had called the victim, whereas recovery has been made from the present petitioners. Full stop.
আমরা নিজেরা
A perusal of the case diary indicates that the prosecution has been sufficiently able to link the petitioners with the crime, comma, at least prima facie. Full stop. Moreover, comma, the petitioner's application for bail was rejected as recently as in the month of June 2023. Full stop. No changed circumstance has been brought on record to justify the grant of bail at this juncture. Full stop. Accordingly, CRM DB 4222 of 2023 is dismissed.
I'm deeply obliged.
Grateful.
Well, may I take back the case?
Oh, absolutely.
And copy of
Is
the
there
order,
Item
copy of the order be kept with the record or not?
Copy of the orders we are keeping on record
I know,
because we are
my
referring.
lord, as your lordship pleases.
Yes.
Item number 51.
My lord, I am not pressing the application.
Learned counsel for the petitioner submits that the petitioner does not want to press the application. Accordingly, CRM such and such is dismissed for non-prosecution. And dismissed for non-prosecution.
51. 51. Item number 51.
51.
Come on, ja.
CRM number, give the CRM number to me.
Yes, my 4223. হ্যাঁ হ্যাঁ শান্তনু
এখন
শান্তনু দেবরায় প্রশ্ন
Give all your names, please, for the state also.
Lordship, item number 52, I am for the petition.
number
Lordship, this renewal of prayer lastly turned down on 17th June 2022 with a direction to conclude the trial within 6 months. Petitioner presently in custody for 3 years, 8 months, and after since the rejection, there was no witness has been examined. 13 witnesses are there to be examined. 13, 13, Lordship. And charge was framed in April 2022.
What is the offense?
Lordship, 376, 506 of the Indian Penal Code and 6 of the POCSO Act. Lordship.
Mr. Datto, no witness examined even despite the direction.
Renewal of prayer of the petitioners just now has come to the vacation.
There was a direction on last June 22 to conclude the trial within 6 months. But no witness has been examined even after that.
For more than 1 year, Lordship.
Lordship knows very
POCSO.
well. POCSO case, Lordship.
POCSO, but
Lordship
Even if
knows
it's a POCSO, he's in
in April
custody.
2022. Lordship.
All time, my lord, very.
No, POCSO. Undoubtedly, there is a
For which,
presumption.
my lord, I'm actually.
Special court is
Supreme Court now is the nowadays the thing is long incarceration.
POCSO case, they are very much alert, Lordship.
NDPS, POCSO,
But
UAPA, everything. Long incarceration is the ground.
Age of the victim, girl, Lordship.
Lordship, special court is there.
10 years victim, girl.
We are not acquitting him.
Lordship,
3 years, 8 months, Lordship, in custody.
What is the age of the victim?
10 years.
But he's an under trial till now, Mr. Datto. We are not acquitting him. Obviously, we cannot.
But condition.
Not do we intend to.
Problem is that your lordship knows very, you're also in charge in RPDR. I am also seeing the code below that actually they.
No, bail does not have any. No, no, offense to clearly.
But let the victim's evidence should be over, lordship. I am no.
Lordship,
But the victim evidence should be over.
Since-
Regular bench lordship, you always will consider the victim's evidence should be considered.
Last,
Always will consider.
since April last year, Lordship,
Is the year only the
evidence not being done.
well, victim evidence should be considered.
Pardon? No, definitely we'll record your arguments on that. Learned counsel for the petitioner contends that the petitioner is already in custody for about 3 years and 8 months. Full stop. At the juncture when the previous bail application of the petitioner was rejected on June 17, 2022, there was a direction passed by a coordinate bench to the effect that the trial shall be concluded within 6 months. Full stop. However, thereafter no witness has been examined as yet. Full stop. Next para. Learned APP submits that the petitioner has been incarcerated regarding offences under the POCSO Act, which are grave in nature. Full stop. It is argued that the age of the victim at the relevant juncture was only 10 years and there is incriminating evidence against the petitioner. Full stop. Next para. It is well settled that while considering the prayer for bail of an under trial, the factors which have to be looked into are not akin to a trial of the case itself, nor is bail equivalent to an acquittal of the victim. Full stop. In spite of there being quite a number of evidences against the petitioner, comma, we are of the opinion that since the petitioner is in long incarceration for about 3 years and 8 months, and the trial did not proceed any further despite the previous direction dated June 17, 2022 to conclude the same within 6 months, comma, the petitioner need not be incarcerated further during the entire period of trial. Full stop. However, comma, in view of the nature of the allegations, the petitioner ought to be put to stringent conditions. Full stop. Accordingly, CRMDB 4224 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner shall furnish bond of rupees 20,000 with 2 sureties of like amount each, one of whom should be local, to the satisfaction of the learned special
POXO court Kagdip
learned judge special court POXO Act Kagdip
And in default, Your Lordship.
Kagdip. Full stop. Moreover, comma, the petitioner shall attend each and every date of trial and shall not leave the territorial jurisdiction of the trial court during the entire period of trial and shall not directly or indirectly ওই যেটা ইনডিউসমেন্ট থ্রেট অর প্রমিস ওটা থাকে আরেকটা লাইন অ্যাড করবেন এটা হয়ে যাওয়ার পর further, comma, the petitioner shall not, comma, in any manner, comma, make any attempt to come in the vicinity of the victim and or contact the victim or any of the witnesses in any manner whatsoever, full stop. In default of any of the above clauses, comma, the bail hereby granted shall stand automatically cancelled.
Grateful, Your Lordship.
বাচ্চাটাকে কন্ট্যাক্ট করতে গেলে ট্রমা হয়ে গেছে
Item number 53.
Yes.
Item number 53, I'm for the petitioner.
Yes.
Well, this is my first application for bail before this honorable court. The petitioner is in custody for 1 year, 7 months and 10 days. The allegations are under sections 498A,
492, yes.
304B, 302, 306 and 34 of the Indian Penal Code.
Yes. Who are you?
My lord, the co-accused
The husband.
This is the husband of the victim, my lord. The co-accused persons are the parents of the petitioner. They are on bail, my lord.
Yes.
My lord, the allegations are such that after marriage, the victim was subjected to physical and mental torture and there was demand for dowry. And on 20th of March 2022, the mother of the victim was called by the petitioner and she was informed that her daughter is admitted in the hospital. On 24th of March,
What was the nature of the injury?
My lord,
poisoning.
My lord, the allegation is that she consumed poison. My lord, so far as the
Postmortem report is
concerned, my lord, there is no opinion with respect to the cause of death because that has been left to the chemical examination report. And so far as the injury, the allegations with respect to the injury is concerned, my lord, the postmortem report indicates that no injury either revealed or concealed could be detected even after careful and thorough dissection and examination. My lord, the injury portion goes.
What injury do you expect? I mean, poisoning. It was a case of poisoning.
My lord, the allegation is that she was subjected to physical harassment also.
Achha.
My lord, the postmortem report does not indicate that. My lord, so far as the charge sheet is concerned, with respect to poisoning, my lord, the matrimonial house of the victim was searched by the investigating agency, and the charge sheet clearly indicates that all rooms are inside the house was searched, but they could not find any bottle containing the traces of poison, my lord. And my lord, she was lastly treated in Narayana Hospital, and the doctors in Narayana Hospital opined that the cause of death to be determined by the medico-legal autopsy. My lord, this apart, there are 2 statements under section 164 which was recorded. My lord, the first statement was of the neighbor of the petitioner, of the victim, and the other one is the cousin brother of the victim. My lord, so far as the neighbor's statement is concerned, he says that he is not aware of what was going on in the matrimonial house and he heard that she had been subjected to torture. And so far as the cousin brother's statement is concerned, he merely stated that the victim was made to undergo an abortion. But my lord, the charge sheet does not indicate that she was made to undergo abortion, and there was no medical evidence that has been collected by the investigating agency, my lord. And the co-accused persons are on bail. I have annexed that order, my lord. It's on page 7.
Persons are on bail because they were aged people.
There are aged people, and my lord, there is
Then
no,
that does not help you.
my lord, but there is also no material that indicates that
Was there
poison.
those orders? Where are those orders?
At page 17. My lord, they were granted bail by the learned court below.
Dying declaration name.
The order starts from page 14.
Is any dying declaration?
No. No dying declaration is there, my lord. Postmortem report is at page 139. And my lord, there are statements, 164 statements of the neighboring people, that is at page 123.
হাউসেই তো ছিল মানে আত্মীয় ছিল না, ওদের সঙ্গেই থাকতো।
চিকিৎসা হচ্ছে আর একটা হসপিটাল থেকে ওয়াশ করেছে আর একটা হসপিটাল যাচ্ছে।
And apart from that, I'm sorry.
Direction নেই বলছে।
Apart from that, my lord, 161 statements are there of the neighboring people.
Neighboring
That's
people does not help actually, but circumstantially, yes, you may have a case.
subject to your
Because she was staying with him at his house.
yes, subject to your lordship's correction, my lord, from the statements of the neighboring people,
Yes.
it transpires that the immediate after the marriage, torture was inflicted. But my lord, I must honestly confess, yes,
You are in custody since?
My lord,
24th of March 22.
1 year, 7 months, and 4 days, 10 days, my lord.
First application also.
My lord.
Learned counsel for the petition, sorry. The learned counsel for the petitioner argues that the case of alleged poisoning made out against the petitioner by the prosecution is not established by cogent evidence, full stop. By relying on the various statements of the co-accused persons and the cousin, comma, it is argued that the said statements do not directly indict the petitioner in any manner in the alleged poisoning of the victim. Full stop. Next para, that apart, comma, two other co-accused persons, comma, being the parents of the petitioner and the in-laws of the victim have already been enlarged on bail. Full stop. Next para, learned counsel for the state opposes the prayer for bail and places reliance on the medical report and the other statements made by the witnesses to argue that there is sufficient case made out against the petitioner. Full stop. Next para. However, comma, we find that insofar as the offense of alleged poisoning is concerned, comma, the case against the petitioner is circumstantial. Full stop. In any event, comma, there is nothing to indicate further necessity of incarceration of the petitioner or custodial trial. Full stop. Accordingly, CRM DB 4225 of 2023 is allowed, granting bail to the petitioner on condition. আপনি আগের কন্ডিশন গুলো কি নিয়েছেন আপনারা কেউ? দেখে নিন। 10,000 to sureties like amountage to the satisfaction of which court?
CJM Barashat.
CJM Barashat. ওই বাকিগুলো দেখে নেবেন কন্ডিশন।
Would your lordships kindly record one thing, my lord?
Yes.
My lord, the evidence has already been started, and my lord, next date has been fixed on 18th and 19th of December.
How many witnesses are there?
My lord, who have been examined completely. 25 witnesses are
26
there.
witnesses as per the charge sheet.
Would your lordships kindly record it that next date is fixed on such and such.
What is the relevance of that, Mr. Amuli?
My lord,
It will be evident from the records itself.
my lord.
Grateful, my lords.
Because if there were few witnesses, then we could have recorded maybe.
My lord, I am grateful.
Item number 54.
Yes.
Private for the petitioner, lord. Lord, with regard to plucking of Lord mango, Lord, two family broke out. There was
You
a
could eat the mango. You eat the mango ultimately.
Ultimately,
If you ate the mango, that's sufficient. You should be released.
Lord, there is a brawl between the two families.
What happened due to the plucking? What is the serious of
Lord,
it?
subsequently, Lord, there is a quarrel, and as I said, Lord, there is a
302, plucking
brawl.
of mango. You're starting with
The
plucking.
case would have been Lord 304. Out, Lord, charge sheet has been filed. Out of 16 accused persons, 12 are on bail. One of the co-accused has
Same
been
footing.
granted anticipated. I'll not.
Let him complete. Yes.
And 12 are on bail. 2 are in custody and 2 are absconding. So these are 16. I'm renewing my prayer for bail. Lord, I could see, Lord, from the document of 207 that there are 2 eyewitnesses, allegedly the wife of the victim and the brother. Lord, so far the petitioner number 1, Lord, my prayer was turned down only on the ground that I have made the fatal blow. But all have come together. I have made the fatal blow.
so far petitioner number 1 is concerned. But all have bodily come, and Lord, as I said, Lord, there was a brawl between the two. And the petitioner number 1 is in custody for 3 years, 3 months, and Lord, the petitioner number 1 is in custody for 1 year, 3 months. Charge has not been framed yet. Only Lord, copies has been supplied. So there is a bleak chances of trial. Lord, I'm in custody.
Number 1, my lord, Prahlad Ghosh, and petitioner number 2, Somnath, my lord. Kindly see 164 statement, my lord. The name of the present petitioners, my lord, categorically stated, my lord.
I'd be beseeching
And the specific act, my lord, done by this petitioner, my lord. Another 164 statement is there, my lord. Prayer for petitioner number 1, rejected 4th time, my lord. And petitioner number 2, 3 times.
That is the PM report.
PM report, my lord, page 68, 78, my lord. And my lord, kindly come to page, my lord, 63, my lord. The injury report, injury, my lord. Page 63, I have folded. Page 63, my lord. I have folded this page, my lord.
Cause of death was due to the injuries.
Kindly see the injury report, my lord. Page 63, my lord, injury report.
Which is कुछ which is कुछ
But so far,
refusing sir.
but so far petitioner number 2 is concerned, Lord. So far
Serious allegation against you also. He rightly
that is the reason, Lord, I was showing your lordship, Lord. I could get, Lord, the statement of Lord.
Prahlad is in Daityakul actually. The others also are equally involved. Somrat against Somrat.
It is
There is direct
Basudev.
allegation. You have hit.
It is
You have punctured
May
the
I
lungs.
may I just give, Lord, the wife, Lord. She is an eyewitness. Lord, she would kindly say, just mark
164 is
164 statement is there.
164 also says the same. Lord, kindly see. It is Basudev and Lord Prahlad. Basudev is on ball. So far petitioner number 2 is concerned, I am pressing. So far 1 is
No, no,
concerned.
two also against Somrat. The allegation is he hit with something.
All are
Punctured the lungs.
rest are on
That's the
bail.
allegation.
Rest are on bail. It is Prahlad who has made the fatal blow. Basudev is the person who has been named. Basudev is also on bail. So, Lord,
When many persons are involved in the offense, then it is not possible for the eyewitness. He has done so. He has done so. He has
that is
done
the
so.
that is the
To
state.
give a minute detail.
That is the statement in 164. So far 1 is concerned, Lord, I am not saying anything. So far 2 is concerned, I beseech your lordship, Lord, to take it.
Also same statement has been made. Similar statement.
She is an
It is
eyewitness.
not on a better
4
footing.
times
All relying on this, there are other 164s also.
164, I have also checked, Lord. It is said that Prahlad is the person who.
Somrat also.
there.
Could you read out what was the page number again?
Yes, Lord, I have got a copy of the 164. So far 2 is concerned, I beseech your lordship, Lord, take a lenient view. Lord, I'll be in
Prahlad Somrat একই জায়গায় একই ফুটিং এ যদি
Lord, Prahlad is the person who has made punctured, Lord, as your lordship, Lord, has indicated.
He cut his hand.
Who is the person who was only a part of the, Lord, family gang?
Learned
Lord,
counsel for the
to-
petitioner
Lord,
content.
kindly any condition. So far
Learned
2 is
counsel
concerned.
for the petitioner's contents that the allegations against the petitioners do not justify the long period of incarceration of the petitioners who serve. More particularly, it is submitted that there is nothing in the statements under section 164 CRPC to indict the petitioner number 2. Next para. However, we find from the materials on record that the present petitioners were on different footing from the co-accused persons who have been enlarged on bail. The allegations against both the petitioners are specific insofar as the statements under section 164 is concerned. The involvement of the petitioners in the alleged offense, which is grievous in nature, being prima facie direct, we are not inclined to grant bail to the petitioners. Accordingly, CRM DB 4226 of 2023 is dismissed. Sorry, Mr.
Obliged, not obliged. So may I take back
Yes,
that page?
it
Item number 55.
I have read the assistant state.
My lord, you are for the de facto complainant, supporting or against? Against.
Always to be
You don't have any locus standi to oppose any prayer.
Now,
Yes, sir.
my lord, peculiar set of events.
Let
Way
them
back,
Let
Milord,
them fight.
some facts may be detailed out, my lord.
Yes.
They may be necessary.
Yes.
Way back in 2019, the informant's son, he had gone to Rishra to his aunt's house. There, a person called Sonu. Sonu called him to settle a dispute that the complainant's son Shabir was having with the local residents. So he went over, met Sonu and his other friends and henchmen, whatever may be stated by the state. And from 21st of October 2019, he could not be traced out. 4 days later, in the meantime, a GD was filed and all that. My lord, on 25th, his body could be recovered.
Sonu.
So, Shabir. Now, a case was initiated 302. 12 persons were named. I am not one of them. Subsequently, charge sheet was filed where some persons were discharged and I and 5 others, we were charge sheeted. Now, I surrendered and I was granted bail by the jurisdictional court after 4 months. I was granted bail. But that there was a condition in the bail that I would not enter the jurisdiction of Uttar 24 Parganas North. My lord, allegedly, I had violated that condition as per my learned friend's client's application. And cancellation was moved before the Honorable Court. And on that ground that I had violated that condition, although, my lord, my instruction is that since I was not communicated the last portion of the order properly, there was a mistake on my part. My lord, I was directed to surrender. I finally surrendered on 13/10/2022. And since then, I am in custody, my lord. My lord, I had pointed out this fact to the coordinate bench.
He jumped bail. Why should you be lenient in your?
My lord, I did not jump ban. I was appearing. Only thing is, I had violated a condition by entering 24 Parganas North. It is not a case that I absconded completely from at that period when my bail was cancelled. Now, subsequently, my lord, I was arrested in connection with another case, and still then I am here. Now, if your lordship comes to the order of this court, your lordship sees my annexure P1, 7/2/2022, when my bail was cancelled. Page 12. Now, this was as of now, apart from all other things, last page of your lordship's brief.
It was very recently rejected.
Yes, then what happened?
Then last page of your lordship's brief is the order sheet. If your lordship sees, first line, all the other persons, even people standing on who are FIR named, even I was not FIR named, all are on bail. And Sonu Singh, the person who had called him for that settlement, Shibu Jadhav, who had previously threatened him, previously tried to attack him, everybody is on bail. I am not on bail because the coordinate division bench cancelled it, and subsequently my application also 6/7/2023. Before that,
what is the change circumstance after
the only as of now, my lord, there is still this is 2019. I am in custody since for more than 1 year as of now.
Only 4 months have elapsed after this rejection.
Well, there is absolutely no progress in trial. Nothing.
In 4 months may not be. I mean, we'll direct
the only difference, lordship sees everybody whoever my worse footing than me, they are on also.
No, Mr. Chatterjee, you only 4 months back your bail was rejected.
That is pointed out, my lord.
And there the grounds have been given. These 2 grounds have been criminal antecedents and the
Because
previous.
he was arrested with another case, and
The difficulty is once there's a stigma on him because it was a detailed order of justice post execution.
my lord, since may I brave one thing then in that event, my lord, subject to my lord will not
praise.
No, let it go over to Justice Bakshi, my lord, justice because
That is bad practice, Mr. Chatterjee.
no, that is why I'll.
Yes, Mr. Datta, anything to add?
It is turned down by the that's your lordship heard it, lordship. I have no more submission.
Learned counsel for the petitioner submits that although previously the petitioner was granted bail, the same was cancelled subsequently due to alleged violation of one of the conditions, being not to enter the district to North 24 Parganas. First up, it is contended that the said violation was not intentional, comma, since the petitioner was not properly aware of the said condition. First up, next para, subsequently, comma, the petitioner's further application for bail was rejected on July 6, 2023. Full stop, however, comma, other co-accused persons have been enlarged on bail. Full stop, next para, learned counsel for the de facto complainant as well as the state vehemently opposed the prayer for bail and contend that in view of the circumstances in the present case, comma, the said prayer ought to be refused. Full stop, we find from the order dated July 6, 2023 of the coordinate bench, comma, whereby the petitioner's bail was rejected, comma, that the said division bench clearly took into consideration all the surrounding circumstances, comma, including the fact that the petitioner had been enlarged on bail earlier but had violated the conditions of bail and had been rearrested, as well as that the petitioner has criminal antecedents. Full stop, next para, since only about 4 months have elapsed after the previous rejection, comma, we do not find any change of circumstances to grant bail to the petitioner, full stop. Accordingly, CRM DB 4227 of 2023 is dismissed.
My lord, consolation price, trial.
Yes, absolutely. However, comma, keeping in view the long period of incarceration, what is the period of incarceration? Period of custody?
My lord, presently 1 year after the
Long period to দেবে না তাহলে? However, comma, the trial court is directed to expedite the trial as far as possible and conclude the same, preferably within how many witnesses, Mr. Dotto?
Because this is a matter of 2019. That is why.
No, how many witnesses are left? Preferably within 6 months from date.
6 months it will.
That's why we are asking. How many witnesses?
26 to 27.
That is what we are asking. Then 1 year. 6 months to 1 year. Preferably within 1 year from date. Thank you. Yes.
No, Mr. Bidyut Roy is back.
তুমি তো আছো তো করে দাও
Reading the matter, Passover matter.
Mr. Roy in this matter.
Mr. Roy has just gone out. Asked me.
Has gone
No,
to
we have a fixed 330 fixed matter. Passover টা দেবে না পড়তে থাকো।
But
56 my lord, I am for the
56 years.
his junior is there.
I am for the
Item
petition.
number 56.
I am for the, I appear for the state. I am for the petitioner. my
Yes,
lord.
yes, what is the
My
matter?
lord, this is my renewal of prayer, my lord.
Yes,
Prayer has been rejected in the month of February, my lord.
এটা জজ সাহেবকে
My lord, this is the case under section 302 of the Indian Penal Code.
কবে হয়েছে?
My lord, my point is that, my lord, in the FIR, my lord, in the FIR which I have been annexed, my lord.
Yes.
Page 9 to 15, my lord. In the FIR maker is de facto complaint is the son of the deceased. In his FIR, he has been stated that there was a previous dispute between the parties,
right?
And for which they all left the place. His mother in the village. She went to the field, and then, my lord, the persons, female persons of the FIR named accused, my lord, they are also in the field. They started abusing her, subsequently assaulted her. Then she ran back to his house, and he fall down and thereafter died. This is the allegation, my lord. All the allegation of assault is by the female accused persons, my lord. Now, my lord, the case has been initially started under section 302. Subsequently, after investigation, final report has been submitted as a mistake of fact. Thereafter, a writ petition has been filed, an Naraji petition, and subsequently, again, further investigation has been started, and thereafter, my lord, charge sheet has been submitted, and we are in the charge sheeted accused, my lord. My lord, I am in the custody since 30th May 2022. Now I am in custody for 512 days, my lord. My point is that, my lord, kindly peruse. The body was found as a hanging condition in the house of the deceased. in the house. And kindly see the inquest report. Body was found in the house of the deceased. Allegation of assault against the female accused persons of the case. And my lord,
What is your role as per the charge sheet? What is your role in the offense?
my lord, if my lord go for the FIR, my lord, there is
Charge sheet.
in the charge sheet, my lord, against us, my Is lord, there the- omnibus is there any allegation, case? my lord. We all assaulted her. That's her. That's her. My lord, kindly peruse only one thing. Only one thing, my lord. Since charge sheet, my lord, 20th July 2022, no progress, nothing. We are in custody, my lord. I am in custody, my lord. And my lord, kindly peruse the PM report. In the PM report also, it is caused due to the hanging. And the inquest report shows that the lady was found hanging in her own house. And according
The allegation against you is assault.
allegation, if according
In
to
the charge sheet.
in the charge sheet, my lord, all names are there, my lord. Nothing has been.
Yes, what do you say, Mr. Vanis?
But this is checkered history of this case. But when the case was started against the unknown persons, thereafter,
No, finally, Mr.
no,
Banerjee, what
mistake of fact. No, Lordship, kindly consider. this.
yes.
The de facto complainant filed the Naraji, but nothing was done by the land court below. Then she moved to a writ petition here. This honorable court, which is a matter case of 2020, this honorable court passed an order directing to continue the investigation and directing not by the earlier investigating officer, but the new officer should be appointed and he will investigate. Then Lord the SP Birbhum of the concerned district appointed the new investigating officer and started investigation. Then unearthed the entire facts. If your lordship kindly see, my learned friend is relied upon the postmortem report. The postmortem report, your lordship will find page 18.
Yes.
Page 18. Kindly see several injuries. Several in middle portion, right hand side. Several injuries, ligature, and everything. And my lord, not only that, and not only that, your lordship will satisfy to see the photographs. Photographs at
No, the cause of death we find there's a ligature around the neck.
No, injuries, last death, cause of death, last portion,
Cause of death,
left hand side, last, cause of death, at the bottom,
hanging man.
antemortem injuries.
Antemortem injuries were there. For
yes.
the injuries, there may be allegations against him. But hanging is the cause of death.
No, hanging, but they hanged. No, lordship, kindly see.
Any of the eyewitness saw hanging.
187, kindly see.
Kindly peruse the
187.
my humble request is
187, kindly see
when it has been recorded. An eyewitness has been seen that we are hanging.
It's a matter of trial. It's a matter of
Trial.
trial.
Kindly peruse.
Something.
When
187.
She was alive, then she was hanged.
Yes. And your lordship will find
all injury antemortem and hanging also antemortem.
One of my lordship, kindly see the photograph.
187, what does 187 this?
187, lordship, kindly see.
Eyewitness.
Eyewitness.
My lord, when it has been recorded, my lord, kindly peruse that. When it has been recorded. My lord,
Dara. Dulal, your petitioner, my lord. Dulal. Gautam late.
My lord, kindly peruse the when it has been recorded. Kindly peruse when it has been recorded.
Gautam, Dulal, all were there.
Family member. Family
Is it? And Lord, photographs 135. Kindly see. 130. Kindly see the 130.
My lord, may I submit only one
Lordship
thing?
will satisfy.
Only submission.
Will be satisfied upon seeing the photograph.
Lordship, kindly see Lord photograph.
Postmortem report is ligature. What satisfaction can we derive from the photograph?
Lordship, kindly see the photograph.
Satisfied হয়েছেন আপনি photograph থেকে? Photograph হ্যাঁ করে দেখুন। Ligature mark রয়েছে clear খুনের।
My lord, only one submission. Kindly peruse that when it has been recorded, my lord, the 164
Later on reinvestigation, the circumstances are very checkered actually.
But
There was a direction by High Court to reinvestigate only upon which
Yes,
this was unearthed.
And one person has been absconding.
My lord, but all the allegation of assault is, my lord, against the female accused.
And all
that has been mentioned in the FIR, my lord.
And all are in jail. All are in jail custody. Nobody has been granted.
Reinvestigation বেরিয়েছে, sorry.
Nobody has been granted.
Learned counsel for the petitioner seeks to highlight that the plinth of the allegations were of assault outside the house of the victim, comma, primarily by females. Full stop. It is submitted that initially the investigation did not fructify. Full stop. However, subsequently, upon the direction of this court, comma, a reinvestigation was conducted, upon which certain allegations were made against the petitioner. Full stop. It is thus contended that the circumstances justify the enlargement of the petitioner on bail. Full stop. It is further argued that the petitioner is already in custody for more than 500 days. Full stop. Next para. Learned counsel for the state seriously opposes the prayer for bail and argues that initially there was some latches in the investigation, comma, for which a new investigation was directed by this court to conduct a re-investigation, comma, when the actual facts were unearthed. Full stop. In the statements of one of the witnesses, comma, it is found that the said witness himself saw the commission of the offense by the petitioner. Full stop. Hence, comma, on the basis of such eyewitness evidence, eyewitness statement, and the gravity of the offense, comma, the prayer for bail is opposed. Full stop. Upon considering the materials on record, comma, we are of the opinion that upon re-investigation, comma, sufficient prima facie evidence has been brought on record to indicate the involvement of the petitioner in the offense, at least prima facie. Full stop. Hence, comma, considering the gravity of the offense alleged, we are not inclined to grant bail to the petitioner. Hence, CRMDB 4228 of 2023 is dismissed.
There may be a direction, my lord, because we are in the custody for.
What is the stage of the trial?
Nothing.
Re-investigation after
No,
investigation.
charge sheet has been submitted.
When?
Charge sheet has been submitted, my lord, in the July 22.
How many witnesses?
23.
Have you got any idea, Mr. Banerjee, how many witnesses approximately?
14 witnesses. Charge sheet I have annexed the charge sheet, my lord.
Yes. Should we direct within 1 year, Mr. Banerjee?
My lord.
1 year trial. It is, comma, however, comma, expected that the after
Commitment, where case has not been committed, I do not have. That's why, my lord.
after it is, however, expected that the trial will be concluded as expeditiously as possible, comma, preferably within 1 year after commitment.
Deeply obliged, your lordship. Deeply obliged, your lordship. Well, may I take back the case?
Case diary.
I am deeply obliged, your lordship.
C30 table copy. C30 কি ছিল?
Passover matter 48. Passover matter 48.
অরিজিনাল সাইট কোটা থেকে ছিল?
3.5
C30 থেকে তো? যেটা 200 কত আছে সেটা কোন other matters are released, only one fixed matter, 330 fixed matter after the original side.
Passover matter, your lordship will take up.
Passover matter, both sides are there?
Circuit bench matter.
No, other matters is not other. No. Only the C30 matter.
The others, only the
Others are released, yes. Other appellate side matters are released.
C30 matter and the other appellate side matters are released.
Are released, yes. C30 matter, then we have our original side matters, then we'll take. No other matters. No other appellate side matters, only one C30 matter is.
Release the matter, my lord.
one of my matters.
এদিকে চলো।
My lord.
C30 তে ডাকুন। কি করছেন?
My lord.
মাইকে রাখুন আপনার গলা আমি শুনতে পাচ্ছি।
Item number 2133 fixed matter.
I beg to appear on behalf of the appeal.
My lord, I appear for the pollution control.
This is relating to, my lord, the maximum noise level. It was 90 decibel. By a stroke of pen, my lord, it has been enhanced to.
Keep quiet for a minute. You are speaking about noise level.
Noise.
Keep quiet for a minute. You want to argue after that? Yes.
My lord,
noise level is our birthright.
Yes. It is, my lord, 90 decibel. After a protracted litigation and, my lord, the pressure up by the pressure group, my lord, finally in the year 2017, the Pollution Control Board decided, after examining the expert committee report, that it should be 90, keeping in the mind the present geographical position of the West Bengal and the city of Calcutta. Now, my lord, in the month of October, 17th October, my lord, by a stroke of pen, my lord, they have increased it up to 125 decibel.
They means the pollution control.
Pollution control board. Prior to that, when I'm drawing lordship attention, kindly come to page 35. Previous round of litigation, what lead them to do all these things, my lord, page 34, 35. My lord, these type of litigations are going on. Lordship, kindly recall, my lord, number of matters are there. My lord, relating to, my lord, that Arjun Gopal matter and others, firecracker. Lordship, kindly come to page 34. 34 starts from, my lord, this, the another application, public interest litigation, order passed by this honorable court, page 40, my lord. My lord, certain directions are given. There must be Baji Bajar, there must be Pesho Niri, super surveillance and all these things. My lord, in spite of all this, my lord, number of, my lord, the guideline issued by this honorable court, certainly the, my lord, the government of West Bengal, page 72 may kindly be looked into, issued one notification by the, my lord, MSME department, micro, small and medium enterprise and textile department, my lord, in the month of September. Here, my lord, they have permitted, my lord, the district magistrate.
Give us half a minute. এই ইয়ে এখানে কোনো ট্যাগ আছে, ওই ট্যাগ গুলো থাকে না, ট্যাগ হলুদ পেজ মার্ক আপনি এনেছেন? না না, ও আপনার তো লাগবে। Yes, please.
Here, my lord, the government of West Bengal certainly keeping aside, my lord, the pollution control board, those who are looking after this issue for a considerable period of time, that is the provision of the law. Micro, small and medium enterprise and textile department is permitted to issue license for, my lord, for a month, my lord, for, my lord, the sale of firecracker and all these things, license are to be issued by this particular department.
This is green fireworks which is permitted
green
by the
cracker, my lord, because of this honorable court at a point of time decided, since
ultimately went up to the
Supreme Court,
permitted.
Green cracker is permissible, reduction, my lord, emission is, my lord, reduced as a result of which 72, my lord, micro, small and medium enterprise and textile department, my lord, bring into the, my lord, the scene. We have drawn attention, one pending matter is there. That matter where, my lord, Honorable Justice Joyamallo Bagchi and, my lord, the companion justice, the passed order. Immediately after that, my lord, what happened? Lordship, kindly come to, my lord, page 58. My lord, page 58, the pollution control board certainly, my lord, awake up from the deep slumber and took up the issue in their own hand and issued this particular circular, my lord. 17/10/2023. My lord, they have reiterated, my lord, the control of the pollution control board, Neri Pesho, will be there in terms of the order of the honorable division bench. But, my lord, lordship, kindly come to, my lord, next page, page 59. My lord, internal page 3. Lordship, got it? In continuation of the above noise level limit for the sound emitting green firecracker, my lord, shall be within 125 decibel. And the light emitting green firecracker shall be within 90 decibel measured at a distance of 4 meters from the point of bursting as per the formulation of the CSIR and NERI. My lord, this particular portion, my lord, is dangerous because of for a considerable and protected, my lord, the fight. This was reduced to 90 decibel. Certainly, my lord, they have decided to do all these things.
Mr. Chakraborty, first of all, the court is not an expert in this field.
That is why, my lord.
Can you show us something to indicate that 90 is the?
Yes, my lord. That is, my lord, the expert committee formed by the pollution control board and pollution control.
Shows that? Shows. No, no, it's not annexed. It should be annexed. That is the first thing.
No, my lord, this is subsequent. Immediately, we have filed this application. This is there, my lord, the circular on office order. We have collected this, my lord. It seems, my lord, there was expert committee. Expert committee filed the report at least on 2 occasions. One by Abirlal Mukherjee, my lord, being the chairperson, and then, my lord, Dr.
Have you got extra copies of those?
Yes, my lord. Yes, I am also supplying them. Then, my lord, kindly see. Kindly see, my lord. Kindly see, my lord, the person to, my lord. In
first,
one,
let us see this.
I am showing.
Where has it been stated?
My lord, may I read, my lord?
No, 90. Yes, yes. Page 2.
Page 2, my lord. Page 2, and they have taken, my lord, page 3, my lord, at the bottom, lord, you will find, whereas the state board has considered the aforementioned recommendation of the expert committee and consulted with the Central Pollution Control Board on 17/4/2017 in this matter. And thereafter, my lord, this direction was issued, page 4. Next, turn to next page, my lord. My lord, referred the certain provisions of the law, and then, my lord, the direction, 4-fold direction. The maximum permissible noise level of the firecracker at the time of bursting within the state of West Bengal must not exceed 90 decibel, impulse noise at 5 meters from the source. There shall be a complete ban on bursting sound emitting firecracker between 10 a.m. to 6 a.m. Our humble submission, my lord, since at least on 2 occasions and number of, my lord, the litigation before this honorable court, that judgment is also with me. There was a direction to form, my lord, the expert committee, and expert committee filed a report. My lord, if they intend to change this from 90 to 125, they must, my lord, take the opinion of the expert. Unless expert opine there is a change circumstances in West Bengal and Calcutta itself, this decibel is required to be, my lord, increased. They cannot do all these things. And my lord, at the same time, in the particular circular, which is page 58 and 59, my lord, they did not say the previous circular existing in this field, and they in supersession of all previous circulars.
The previous circular,
Previous circular, my lord, that is, my lord, page 57. Lords, you will find page 57, present circular, my lord, the present circular, and this was the previous, which I have handed over before this honorable court.
No, this is an. Acha, very well.
Yes, my lord. Page 58 and 59, now they have issued, only when we draw the attention of this honorable court, that MSME, the appropriate, not the appropriate department, they cannot do anything. They have reiterated the order passed by the honorable division bench, and at the same time, this particular paragraph has been inserted.
What is the MSME order?
MSME, my lord, kindly come to page 72.
Oh, that's 72, right, right.
MSME. Now, my lord, they are not pressing this MSME. So far, they have not cancelled it, but at the same time, my lord, on the same breath,
MSME does not specify anything regarding the decibel.
yes, my lord, they are going to issue license. Lordship will come to, my lord, page 55, where the public interest litigation court, my lord, took into consideration and handed over this particular circular before the public interest litigation court. That is page 55.
Which circular?
Well, that particular circular, the recent circular which is impugned, which we have challenged, this was handed over on that particular date. We have brought into the notice of this particular MSME circular before the honorable appeal court. At that point of time, the pollution control board come before the honorable appeal court and handed over this particular document, which is impugned before this honorable court. Page 55, my lord, kindly see, this is the order passed by the honorable public interest litigation court in a different matter. My lord, that being the situation, here our humble submission.
What direction was passed by this?
Kindly see, my lord, page 55.
55, yes.
Page 55, the learned advocate, I am reading, my lord, the next paragraph. Appearing for the pollution control board has submitted. Then an order has been passed under section 30A, 31 capital A of Air Prevention Control and Pollution Act 1981 and rules made thereunder on 17/10/2023, wherein it is made clear that the green firecracker shall be used with the reduced emission and should be manufactured as per the formulation of the CSIR and NERI following the direction of the Honorable Supreme Court dated so and so. Apart from that, the order also specifies the time during which the cracker can be blasted, etc.
So this 150 decibel was not taken note of.
Not taken note of.
Okay, let us see Justice Bhakti's division may.
Kindly come to
whether there is anything regarding this 90 decibel.
No, at that point of time, 90 decibel was accepted proposition of the PCB, and PCB, my lord, issued this particular, my lord, the order in the year 2017, and since then everything is going on. Certainly, my lord, they have enhanced and increased. I don't know, my lord, keeping in the density of the city, keeping in the density of the West Bengal population density, this was taken into consideration, and expert are of the opinion this should be done. And my lord, as to how, my lord, PCB by a stroke of pen, my lord, change this whole thing, my lord.
So let us hear them.
Yes, ma'am.
Yes.
My lord, I'll take your lordship to the document, but my first submission will be, my lord, subject to your lordship's correction. But this is a completely misuse of the process of the court. I tell your lordship, my lordship kindly takes the first circular of 2021 of the Pollution Control Board. That is at page 57.
Yes.
Now, my lord, kindly sees the first paragraph of that. Well, it was issued following three things. One is the Honorable Supreme Court's order in Arjun Gopal. Lordships are aware of this. The first paragraph itself sets out.
Yes.
The number of the case. This is the Arjun Gopal's case. In Arjun Gopal's case, my lord, lordships will recollect that, my lord, I can give you the paragraph. Lordships will recollect that the Honorable Supreme Court stated that only green crackers will be issued.
Yes, yes.
Lordship remembers. And paragraph 48, if I am not wrong, stated that it should be the permissible sound limit. Now, my lord, so the Honorable the Supreme Court's case and also following two cases of the National Green Tribunal, which followed the Supreme Court's order, obviously. Now, my lord, this was the position.
Now you have increased the permissible limit itself.
I'll tell you, lordship. Now, following this, my lord, this honorable court, my lord, the matter was filed by my petitioners. The order is at page 34, the last vacation bench. the last year's vacation bench. Page 34, 11th of October 2022.
Yes.
Well, this order which your lordship has just seen was challenged by my learned friend. The PCB circular at page 38, at 57 was challenged. Number of the honorable division bench takes at page 34, number of certain portions kindly skips over, kindly takes page 36. My lord, this third paragraph, my lord, the honorable division bench sets up, my lord, takes notes of the Arjun Gopal's case of Supreme Court. Then, my lord, sets out the honorable Supreme Court's order. Now, my lord, kindly takes next page is 38. Page 38, my lord, the 2021 circular of the Pollution Control Board has been set out. Now, my lord, then takes the next page, the last paragraph, page 39. Mechanism to determine which crackers can be treated as green crackers has already been spelled out by the apex court in Gautam Roy and another. Now, my lord, then it goes on to the next page, the directions have been given. Kindly takes page 440. These directions were given. Now, my lord, after this, the same matter, my lord, this pending matter, my lord, the affidavits were filed wherein the compliance report as per the honorable division bench's order has been filed by the Pollution Control Board and the state government. Now, my lord, this matter, a supplementary affidavit was taken out by my learned friend. My lord, I have one copy of the supplementary affidavit. I'm sorry, my lord, I'm giving it to your lordship. In this supplementary affidavit, my learned friends, my lord, in the pending writ PIL now, which has been disposed of by the bench, by the presided over by Honorable Chief Justice, my lord, challenge the MSME order of the state government, which is at page 57 of this. This was under challenge. Kindly takes this. Kindly sees this paragraph. The MSME order is again annexed here at page 72 and again challenged in this writ petition. It is the prayer is challenging this.
Very well. MSME you are ignoring for the time.
Not. His lordship kindly ignores. Now, my lord, kindly takes the what order the division bench passes, which is at page 43 of this writ petition. My lord, kindly see the first paragraph. The order and direction issued by this court on 11th October 2022, which has just placed before your lordship, shall be scrupulously complied with. And the learned government advocate submits that the directions will be scrupulously. What are the directions? As the modality set out. Then kindly sees the learned advocate appearing for the Pollution Control Board. My lord, this order of 17th October was placed. My lord, kindly keeps that paragraph once, wherein it is made clear that green firecracker shall be used with the reduced emission and should be manufactured as per formulation of CSIR and NERI, following the direction of Honorable Supreme Court. Then, apart from that, the order also specifies the time during which the crackers can be blasted, etc., which is reiteration. Then, very important further, with regard to the noise level, also directions have been issued. So, my lord, the honorable division bench takes note of the increased decibel level. Then it goes on to say, thus we wish and hope that the state will be able to implement the orders passed earlier and the directions issued by the Pollution Control Board. And in this regard, a circular can be sent to all the district magistrates. The next page, page 43, is the circular issued by the Pollution Control Board. Page 43 of this writ petition is the circular. 43? I'm sorry, 45. Page 45 is the circular issued by the Pollution Control Board in terms of the honorable division bench's order. My lord, wherein, my lord, we just reiterate and annex all the documents. Now, my lord, challenging this, now this writ petition is filed before lordship. My lord, if I may say so, my lord, with the deepest humility, my lord, my learned friend is inviting your lordship to sit over the decision already taken by another court in the honorable division bench. Kindly seize this, my lord, I may not reiterate, your lordship has seen this. Further, with regard to the noise level, also directions have been issued. Then, in the last paragraph, the honorable division bench goes on to say that the directions given by the PCB is to be circulated to all the district magistrates. We have done that. Now, this has been done in terms of the honorable Supreme Court's order in Arjun Gopal. I might just, if I may make this submission, in Arjun Gopal, Supreme Court said this permissible sound limit, reiterating another earlier order of 2005, which stated 125 decibels. Now, this has been taken note of by the honorable division.
This was a continuation of the submission of the learned advocate for the Pollution Control.
Yes.
So this expression, let us see this.
Kindly.
Let us come to para 2. The learned
see.
advocate appearing for the Pollution Control Board has submitted that an order has been passed wherein it is made clear green crackers such and such following the directions of the Honorable Supreme Court of India dated such and such.
Then kindly see the next line.
Apart from that, the order also specifies the time during which
the notation.
Crackers can be blasted, etc.
Further, with regard to the noise level, also directions have been issued. Then kindly see the next paragraph as a corollary. Thus, we wish and hope that the state will be able to implement the orders passed earlier and the directions issued by the Pollution Control Board. So this is a corollary of paragraph 2. So now, my lord and Fed is inviting your lordships to again sit over the, either he should have filed an appropriate application or challenge this order.
Mr. Bihani, can it be said that this direction operates as res judicata on this point? Because this was never argued or considered by the bench.
Correct.
There is no argument on this.
No, this was considered, not argued maybe, but it was considered.
No, the argument regarding 150 decibels was never argued. That argument was never considered because it was never made by them.
Correct, but kindly seize this line with
you only pointed out this and the court said yes, this will be directions will be followed.
Yes,
definitely.
Yes,
but this 150 decimal, 90 decimal,
125.
125 decimal, 90 decimal, this argument was never made. Then how can it be said to have been res judicata by that bench?
No,
it was not adjudicated. It is not.
It was not made, but
even the Supreme Court's obiters are maybe binding. This is not even obiter.
No, it was not made, but it was handed over and the direction was passed. My lord, at least they could have.
The basis of your increasing this?
Yes, the basis is, my lord, the Arjun Gopal's case, wherein Supreme Court says permissible noise level all over India is 125, and the Supreme Court also says that following 2005,
we'll stay the circular, Mr.
Well, this is all over the India. I tell your lordship now, and I tell your lordship, and at that big
all over India.
I tell your lordship, 2017, which he had my lord.
West Bengal pollution control. What all over India?
No, 125 is the green cracker decibel level all over India. This 2017 circular which has been placed at that point of time, the green cracker was not in force. It comes into force on 2018 pursuant to the Honorable Supreme Court direction in Arjun Gopal's case. In 2017, the concept of green crackers itself was not there, so 90 decibels. It was left upon each state.
But what about this, Mr. Bihani, this 2017 circular, that is still there?
That's what I'm saying. That this at that 2017, the concept of green crackers itself was not there. It comes into force in 2018.
If the cracker becomes green, the sound level increases.
The sound level decreases. I tell you, Lordship, one line will suffice.
Then it was when green crackers were not there, according to you. Yes. Then it was 90 decibels was the upper limit.
But kindly
now make it
120. 90 decibels. 90 decibels at a distance of 4 meters from 5 meters from the point of bursting. That was the line. Kindly see 90 decibels at a distance of 5 meters from the point of bursting. Now, green crackers, as per as CSI or NIDI, all over India, is 125 decibels at a distance of 4 meters from the bursting point. That is also stated in the circular. I am following exactly what is all over the proceedings all over the India, all over the country, all over the country. I have not added anything, I have not subtracted, appended, or done anything. I am just following the established procedure. 5 meters, this is 4 meters. In 2017, green crackers was the nullity. There was no concept. But I cannot go beyond and create something new. If he is aggrieved, but he has to challenge this. And one more thing. I'm sorry, my lord. After this, my lord, in 2018, Arjun Gopal, in another matter, the Honorable Supreme Court was challenged. The NGT was challenged by the Supreme Court. The Supreme Court, I can give you, lordship, the reference. The Honorable Supreme Court says we shall not entertain any further deliberations on this point. I'll give you, lordship, the reference.
Yes, 5 meters have become 4 meters.
Yes, from 2018 onwards. And the Honorable Supreme Court, after Arjun Gopal, goes on to say that, I'll give you, lordship, the reference, no further reference deliberations will be done on this, this is final.
That is relating to firecracker.
So that is relating to firecracker.
Deeply observed.
That is not relating to decimal level. But this is what, yes, Mr. Bihani, anything to add? We'll come back to you because we have other matters to take up. Yes, Mr. Chakraborty, how do you deal with this 5 meter and 4 meter?
No, even 5 meter or
maybe may very well be
the state authority.
4 meters within 4 meters is maybe 125. But if it becomes 5 meters, then that it may decrease to 90 decibels.
True, my lord. At the same time, my lord,
yes.
My lord, the state authority, my lord, State Pollution Control Board has the authority, and they have taken permission of the Central Pollution Control Board on the basis of expert committee report. Here also, my lord, they have appointed one expert committee, and on the basis of the report of the expert committee, they can take the decision.
No, this expert committee last report which you cited
is 2017.
That says 90 decimal at 5 meter from the point of bursting.
Yes, my lord.
Now this 125 is 4 meters from the point of bursting. So that very well vary.
In that case, my lord, 125 4 meter, it means, my lord, about 13, my lord, about 14, 20, 12 feet, about 12 feet, or my lord, the thing is this, my lord, on the basis of the report of the expert committee, they have taken this decision. My lord, here, and the same time, my lord, the law also permits, lordship, kindly see, my lord, the Environment Protection Rules 1986. Here, my lord, the notwithstanding provision is also there. 3A may kindly be looked into, my lord, I'm reading.
In reply, you're arguing something else.
My lord, 3A provision is there, my lord.
Go on arguing new cases in
No,
reply, then
not new cases. My lord, the PCB
90 decibel is fixed anywhere.
My lord, 90 decibel is not
No.
fixed in anywhere. But at the same time, my lord, but
Yes.
at the same time, my lord, it is not exceeding 125 decibel. Doesn't mean, my lord, one cannot, my lord.
We cannot be arbitrary on that. Court is not the expert on this.
My lord, that is why, my lord, we are praying, my lord, expert committee may kindly be directed to be appointed. An expert committee, if take decision, my lord, there may be a deliberation. And in the deliberation, all the other expert may come forward before the PCB. My lord, without doing all this thing, by a stroke of pen by the administrative authority on their subjective satisfaction, my lord, did all this thing. And my lord, was certainly produced before the Honorable Read Court. We have got a copy, and then, my lord, we have dealing all this
But
thing.
nothing prevented them from, I'm sorry to interrupt, nothing prevented them from approaching the same bench.
Yes, we'll direct affidavits then, and we'll call for a report if necessary, but no stay order.
The only thing is, my
This level you'll have to suffer 35 decimals.
only difficulty,
Decibels.
only
And
difficulty,
reduce
my lord,
1 meter reduction.
only difficulty is, my lord, the Kali Puja is ahead. And at a point of time, Mr. Vianney strenuously argued before the National Green Tribunal, it should be 90 decibel.
Because at that point of time, there is no green factor.
That particular document is with me. And at the same time, my lord, Arjun,
That particular document is
Mr.
also.
Chakravarti, there is a difference.
handing over, my lord,
We are not may not be convinced otherwise, but 90 decibel is at a distance of 5 meters from the point of bursting.
Lordship.
Now it is 125 within 4 meters from the point of bursting.
Lordship.
There's a distinction between 1 meter. I mean, from the point of bursting of a firecracker, it will be, I mean, just think about the Big Bang.
Considering
The Big Bang, same concept.
considering
It's a small bang.
considering everything, there are at least 2-3 reports before the PCB.
So that was
One by
before
made by Abilal Mukherjee,
No, it will never stop. We will not pass an interim order, but we'll direct it.
only, my lord,
That was
one
before
judgment
the
of
grand green crackers.
my lord,
When counsel for the petitioner strenuously argues that the impugned circular dated October 17, 2023, issued by the member secretary of the West Bengal Pollution Control Board, is palpably dehones the law and the previous directions passed by various courts of law. Push up next para. It is contended that in a previous order dated May 5, 2017, issued with a memo number 4083 capital L stroke WPB-R within bracket capital Roman 8 bracket closed stroke 2015, also issued by the West Bengal Pollution Control Board, the upper limit of firecracker sound was stipulated at 90 small d capital B within bracket capital A at 5 meter from the point of bursting. Full stop. Next para. However, the Pollution Control Board has unilaterally raised the said limit to 125 decibels, without resorting to any expert committee report or otherwise otherwise undertaking any research on the said issue. For sub next para, learned counsel places reliance on a judgment on an order dated October 18, 2023, passed by a coordinate bench in WPA within bracket P 292 of 2021, that the said division bench had clearly directed that the order and direction issued by the court on October 11, 2022 shall be scrupulously complied with. Full stop. Next para. By placing reliance on the order dated October 11, 2022, it is contended that the same contained several measures regarding the stipulations as to bursting of firecrackers and sale and import thereof. Full stop. Next para. It is argued that in patent violation of its own previous order dated May 5, 2017, and the said directions, the unilateral decision was taken by the Pollution Control Board to increase the decibel level, which would adversely affect the health of citizens. Full stop. Next para. Learned counsel appearing for the West Bengal Pollution Control Board argues that the direction of the division bench dated October 18, 2023 was clearly restricted to the previous judgment dated October 11, 2022, which did not stipulate any upper limit for the sound of bursting firecrackers. Full stop. Even the order dated October 18, 2023 included a rider that with regard to the noise level also directions had been issued, and the directions issued by the Pollution Control Board should be implemented. For next para, thus, comma, it is argued that the same point has been decided by the coordinate bench in WPA within bracket P 292 of 2021 and cannot be reopened at this stage. Full stop. Further, comma, it is contended by the Pollution Control Board that the guidelines adhered to by the Pollution Control Board in issuing the impugned circular is in consonance with the norms prevalent all over India and in line with the judgments of the Supreme Court relating to green crackers. Full stop. Next para. A perusal of the direction of the coordinate bench dated October 11, 2022 in WPA within bracket P292 of 2021 indicates that the same pertains primarily to import, sale and bursting of firecrackers and does not stipulate any particular upper sound limit. Full stop. Next para. However, the argument of the Pollution Control Board cannot be accepted that the issue relating to the upper limit of upper sound limit was decided by the division bench on October 18, 2023. Full stop. Next para. The well-established concept of res judicata is that the issue concerned must have been raised, argued, and dealt with by the concerned court having jurisdiction to do so. The present case, a stray observation that the directions issued by the Pollution Control Board, without referring to any argument or adjudication on the question of the upper decibel limit for bursting of firecrackers, cannot debar this court from taking up the issue at this juncture. Full stop. Thus, such contention of the Pollution Control Board is refuted. Full stop. Next para. However, even on merits, it transpires that that learned counsel for the Pollution Control Board is justified in pointing out that the order dated May 5, 2017, issued by the Pollution Control Board clearly delineates the upper sound limit for bursting of firecrackers to 90 decibel small d capital B within bracket A at 5 meter from the point of bursting, whereas the currently impugned circular dated October 17, 2023 stipulates the outer limit to be 125 decibels at a distance of 4 meters in respect of sound emitting green firecrackers. Full stop. Next para. This court, it has to be kept in mind, is not an expert with regard to the upper sound limits. Full stop. However, on a bare perusal and comparison of the two circulars in question, respectively dated May 5, 2017 and October 17, 2023, it is clear that the upper sound limit for bursting of firecrackers have not been significantly increased by the Pollution Control Board. Full stop. However, since the petitioner is justified in arguing that an expert report ought to be called for to ascertain the appropriate upper limit for bursting of firecrackers, keeping in view the health and well-being of humans as well as animals, the respondents are directed to file affidavits in opposition, disclosing therewith appropriate expert reports on the issue. Such affidavit in opposition shall be filed within 3 weeks from date. Reply, if any, shall be filed within 1 week thereafter. Liberty to mention the matter before the appropriate bench for hearing after the expiry of the aforesaid time limit for filing of affidavits. Full stop. However, comma, in view of the above discussions, comma, this court chooses not to pass any interim order in the matter.
Get full roll out.
Lord,
Get full roll.
3 weeks from date. Not from
Weeks from date, yes.
Before your
And
lordship,
for an extreme just for your lordship. I want to file an appeal without certified copy. The order was passed yesterday. Just add without.
Appellate side.
but my lord, the point is that on 4th of November, my
We'll
lord,
release the other matter. We'll
but
take up the
my
original
lord,
matter.
if my
No, we have already
my lord, on
released it.
4th of November, my lord, the
Sorry.
admissions for B.Ed course will be, my lord, closing down.
Sorry, no.
It's of grave urgency, my lord.
I'm just humbly praying, my lord.
No, call on the original said matters, please.
Kindly, my lord, item number 200 times the contempt matter was assigned to your lordship. I'm just humbly praying that my lord be assigned the matter to the next
Nothing.
vacation bench.
Nothing.
I'm not praying for lordship to hear out the matter.
You have the power of assigning.
My lord,
Gone out of your mind entirely.
my lord, my lord, is any order can be
I can
passed?
assign the matter to some other bench. It has been assigned to me by the Chief Justice.
My lord, in any order can be passed?
Can I?
My lord, the matter was running, my lord. That's why I'm just praying, my lord.
I'm assigning it to you. You decide.
My lord, I cannot. I apologize.
Call on the list, please.
My lord, leave granted can be, leave granted to move.
Take the bench. Huh?
My lord,
Where will
leave granted to move the
No.
action bench on a
Yes,
bail application.
how long will you take further? 10 minutes? 10 minutes, 10, not more than that. We have to conclude somewhere. 10 minutes to you, 10 minutes to Mr. Banerjee, and we'll conclude. We'll pass our orders.
Please half an hour.
No, half an hour. We can give you 10 minutes each. We are deciding only the application, the prayer for stay. Interim one.
They argued for much longer. Anyway,
No,
I cannot tell anything.
Yes.
Lord,
Call good.
Lord, I was pointing out to your lordship that unless two ships come simultaneously,
yes,
this can never be. Now, for this, I had produced, my lord, the berthing list before the learned judge. Would your lordship will kindly
I'll
see?
kothay.
Thank you, sir.
It was recorded by the learned single judge that you had produced documents or some materials to show that they were merely carrying on in the other HOJ 2.
Right.
That was observed. We found that observation.
Sure. Your lordship will may kindly see volume 3, page 426.
এটা তো করে রইল। এটা আগের ম্যাটারে একটু অরিজিনাল অ্যাপেলেট সাইডে দিয়ে দিন তুমি এসো। Volume 3, page 426.
426, my lord.
Yes.
This is annexure E to my affidavit.
426, yes.
Yes. Would your lordship will kindly see, this is on top, morning position as on Saturday, 30th September 2023. Little below, vessels inside dock and Aldia. As my lord got it?
Yes.
Just above the column, vessels inside the dock. In the same column, my lord, last but one.
Yes.
MTBWTYR.
Right.
On the left hand side, HON2.
Yes.
HON2. And
Right.
whom, my lord, propane and butane, Hindustan Petroleum. Kindly see, my lord, what I want now at 426. Now, your lordship will kindly see now. The next vessel is only at page 436. I'm on the reverse. At page 436, my lord.
Yes.
436, your lordship, this is 25th September. The same way, my lord,
last but one, HOJ2, BW Oak, Hindustan Petroleum. This second vessel. So, my lord, kindly see, my lord, one vessel comes once in 5 days. One vessel comes once in 5 days.
It cannot be simultaneous.
200%. 200%. And in any case, my lord, I want to put it your lordship this way. If it is coming, the onus was on them. Then they could have easily shown to me, my lord, this document plus when they produce the invoice for the last 1 year, they had all the records to show how many ships came. They did not produce. They withheld it. They withheld it. So, my lord, 436 is the second vessel on 25th September. Now, your lordship will kindly quickly turn over. I am running because of the time limit, my lord, at 446.
Yes.
Second last, my lord, again, the vessel called BW Loyalty.
So average interval is 5 days.
Average is 5 days. So 6 to 7 vessels in a month. Now, kindly, my lord, if your lordship will kindly see the invoices, any invoice, my lord, at volume 1, page 90, any invoice.
Volume 1.
Any invoice, my lord.
Yes.
Page 90, your lordship will see the date of the invoice.
The invoices have a pattern.
No,
There are two for bottling charges, one for
absolutely.
throughput.
And not only that, the date is 2nd February.
Yes.
Every second day. Now, kindly see, my lord. My learned friend pointed out to your lordship 166 divided by 2. Straight away. Now, your lordship will kindly see 3 dates. 14th September was the damage. From 15th September, HOJ1 did not work. I filed an application on 7th October. 11th October, they filed a reply. 11th October. So, my lord, they had the invoice of October. They had the invoice of October 23 is already gone. Which means October 23 for September 23, when 15 days HOJ1 was not working, the invoice is already gone. They don't produce it. Because if they produce, what will be the result? 13 crores. No problem. Absolutely no problem. So, my lord, absolutely a bogus case is being made out. This is a fraud on the court. This is not fraud on me. It is a fraud on the court. Now, kindly see, my lord. Would your lordship will now kindly see for a minute. So, my lord, invoice even if they had produced the invoice will show straight away 13 crores. They would be caught. So they don't produce.
Mr. Rambhadan, we are posed with another competing factor.
Yes.
This is an admiralty jurisdiction suit.
Right.
So which is somewhat different from better than us, from a regular suit, in the sense that if the vessel leaves India, leaves the waters of India, it may be difficult to enforce the whatever award is passed, ultimately whatever degree is passed. So that is one of the considerations. So there, if we balance the conveniences, we have to keep in mind that we have to take their best case on the basis of the materials which they have produced. Right? Not that they have to prove it to the hilt, unlike in a different case. Suppose
my lord.
So we have to keep that.
Lord, I bow to your lordship.
Yes, you are right that we cannot be paranoid for that reason. That whenever a ship leaves, we'll have to extort something from the ship. Not that.
No, my lord.
But we have to be we have to give more leeway to them.
No, kindly, lordship will kindly see. My lord, I have, even in a case where in a breach of contract, where liquidated damages is provided, the defendant can show to the court, prove to the court, no loss is caused, therefore you can't claim LD. That is the law. So here, in a case of negligence in tort, I am able to demonstrate to your lordship, no loss is caused. I have demonstrated on 2 bases, my lord. One, the number of ships, because the whole case is based on my arms are gone, so I lost. Now, kindly see this invoice. This is, my lord, this is not simply his scope of work. The agreement will show. There is, his scope of work virtually starts thereafter. All the work is completely going on. He himself has produced, my lord, after this incident, another vessel. They have produced, my lord. Your lordship will kindly see that the vessel has come on HOJ2. They have produced. Would your lordship will kindly see for a minute?
The work could have been distributed between HOJ1 and HOJ2,
No,
which
no,
they are
no.
having to do through.
My lord, that is why. My lord, that is why HOJ1 and HOJ2, it is their case that both are doing the same operation. How does it matter whether it is one or two?
Unless they simultaneously basis account.
100%. Unless, my lord, two ships come simultaneously, then you could, then also, my lord, your lordship will kindly see, then also, what would happen at the most? The ship will be waiting. Who will be doing this? HPCL. Not them. Ship will be waiting. That's all. And this is not the only berth. You can go to another berth. My lord, I am not going into all this. But the record will show on an average not more than 5 to 6 ships come. How does it matter whether it is HOJ1 or HOJ2? Your lordship posed a pointed question, Admiralty. But I bought your lordship. It is correct. But in an Admiralty, we are talking of, first of all, I have no contract with him.
No, this is not an issue of contract at all.
No, correct.
Contract does not come in at all.
No. Your lordship will kindly see, my lord, the learned judge's finding. No, there is a learned
73. How is section 73 relevant?
No. Learned judge. No, I'm not saying. Learned judge's finding. Finding that there is no plea of duty of care. They fail in the foreseeability test. They have failed in establishing even prima facie. My lord, that is the finding. My lord, now that is why Wander Limited, my lord. When the learned single judge has come to a conclusion, it is based on material. The learned judge has taken all this into account and has come to a conclusion. You have not established. Now, kindly, my lord, if your lordship have to reverse it, what is that the learned judge has not considered, my lord? I put this question to myself. These things will show that 6 ships per month on various days, once in 5 days. There is a berth here, there is a berth here. It doesn't matter the ship goes here or ship goes there. And all other activities of bottling and other charges is being done thereafter. This entire activity is thereafter. And kindly see, my lord, how it is in the nature of speculation. Their own case is 7 months. Now you claim for 1 year. Because purchase order is November 16 and the installation in June 17. Installation is in June 17. So how do you jump when it is installation to 1 year? So, my lord, these are all complete speculation. Not only that, then your lordship is saying the vessel. Now kindly put it the other way also, my lord. Normally in a suit, then you go for enforcement of a foreign decree. It is not that, my lord, it is nowhere, my lord, Capitan Cook says in case of, my lord.
Definitely you are right. That's why we said that we cannot be paranoid also.
No,
just because it's Admiralty, we cannot put the case on a higher footing than the plaintiff has made out. Definitely. That is always there.
They have to show a very strong, not only that, my lord, if a party is withholding document, my lord, I am making this with all responsibility.
The transactions regarding the 2 arms individually.
Absolutely. They could have easily shown, my lord, how many ships come and this is what it is. This is not in my possession. Under section 101 of the Evidence Act, it is in his possession, my lord. I cannot do that. My lord, had he disclosed, then your lordship could have come to a conclusion. My God, so many ships have done nothing. Why have they? My lord, it is not in when you are making a claim for a remote loss, and that too for 1 year, in the sum of 83 crores, the entire owner's burden is on them to show. It can't be Capitan Cook case, so give me all money. So 83, why not 800 crores? Why not 800 crores? So, my lord, so that would your lordship for a minute see Capitan Cook case? Because there The division bench found that there is a triable issue. So, my lord, that is a case of not reduction of security. Capitan Cook's case was a case of vessel being released without security. Would your lordship will kindly see for a minute? Videsh Sanchar Nigam. Would your lordship will kindly see the very same paragraph my learned bench, my learned friend, he says he is relying on at para 15.
15, yes.
The Admiralty action is an action in rem. The division bench found that the claim was not vexatious but is triable.
Yes, yes, definitely.
Now, as against which the learned single judge said, you have not even made a prima facie case. So, my lord, the test is not something different. Prima facie, like 38 Rule 5, my lord. 38 Rule 5, apart from establishing that the defendant is disposing of the assets, you have to make a strong prima facie case that you are likely to succeed. Now, now kindly see, my lord. Now, my lawyer friend will say everything in evidence. No. Under the Commercial Courts Act, you have to produce all documents. Even that 1 month period is over. Period of 30 months is over. Now they can't produce any document because those documents they had in possession and they are not producing it.
The learned single judge was proceeding on the premise of Order 39 Rule 4.
Yes.
If that be so,
Yes.
then the best case for vacating here, because you were not heard when the initial order was passed.
Yes.
So therefore, you only have to establish that something either was suppressed,
yes,
or the court was misled.
Correct.
Misleading is one of the grounds.
Right.
So here you say misleading comes in.
100%. And because, my lord, I do not know unless I am making some mistake. 6 ships come in a month. Is there not onus on them to be fair to the court? 18% in every invoice. Should they not be fair to the court? 18% invoice. Are you taking GST from me?
Regarding GST, Mr. Rambhadan, you are being very candid. Regarding GST and bottling, those can be segregated from their documents also. So even if the court holds that yes, you are right on GST, then that can be segregated.
No.
That's not such a strong argument of yours.
No.
You are right. You are right. You have a point there, but GST is different. Those are side issues.
Correct. I'm no, my lord. I am showing to your lordship the conduct. Because in an admiralty matter, I will tell your lordship, I don't know what in this court in Bombay, we go to the court, some of the judges, yes. The reason is they have full faith in the person who is making.
That is why we have the mace here also. If it's necessary. Physically also it may be necessary.
Sometimes even the learned judge will tell the counsel who is appearing, Mr. So-and-so, are you convinced of the case? Are you convinced of the case? That's all. An order is. And then the matter is really heard thereafter. Because they don't want to waste time. It is an ex parte application. And everybody comes in the last minute, the ship will sail. So there is a full-fledged hearing is never there. So, my lord, today to go back to the original order may not be appropriate. Now, with greatest respect, my lord, that order is subsumed in the next order. We are with an order of the learned single judge who has vacated upon, and I have secured the damage claim. It is not that I am running away. I have secured the damage claim. Now, kindly see, my lord, for a minute, one judgment on negligence, my lord.
If we heard you correctly, probably you are agreeable to double that also as a gesture of bona fide.
Very well, my lord.
You said that probably.
Yes.
If you are correct.
Yes. Since I have told them, my lord, I will.
Because the costs may have increased regarding equipment also.
I'm sorry.
The costs may have increased.
No difficulty, my lord. Since I have
it. You heard it being said by you.
Yes, I did, my lord. I did. I'm not saying no.
Right.
So, my lord, I don't mind. I don't mind. So, my lord, since that fell from the last week also, because for me, every day, it costs money for the vessel. And, my lord, I am a party who have succeeded. It is not in the reverse. My lord, if I had not succeeded, then it is difficult. Suppose I had said, there is no case for arrest and the judge has rejected that. Then if I have to satisfy, it is a different. Today, my lord, it is completely in a different footing. I have succeeded, my lord. Yet I am saying, since we don't want to go into a full-fledged hearing on on so many aspects, my lord.
Stay order subsisting till today. Stay order is there from the appellate court.
Yes, yes, yeah.
Which we extended till today. Yes.
Absolutely correct. Because I have even acted upon the order. I have deposited already. And in fact, one most disturbing factor is after, despite there is no stay, the marshal did not act even after we have paid the money. This is most disturbing thing which, my lord, if your lordship has seen recently, the Supreme Court has pulled up even NCLT members. It is most disturbing thing. I am not, doesn't matter. The point is, they requested the learned judge has rejected. Right or wrong is immaterial. The stay has been rejected. I have deposited. How can the marshal say appeal is filed, therefore I will remain? Is it the duty of the marshal not to release and not to act upon the court's order? There is a direction by the lower single judge, upon deposit, the ship shall sail. Well, this is not fair. My lord, I would only point out a judgment on negligence, law of negligence, my lord.
Yes.
Managing, no, not this managing. If you got is fine. You got really is fine. Otherwise, I'll take it.
This one, yes.
Yeah, you got it. Yeah, it's all. Yeah, I got it.
Yes.
Only on the legal things, my lord. Your lordship will kindly say para 7.
Right.
Negligence as a tort is a breach of duty caused by omission to do something which a reasonable man would do, or doing something which a prudent and reasonable man would not do. The court listed the following elements which constitute negligence: legal duty to exercise duty of care, due care, breach of duty, consequential damages. Now kindly see para 8. The elements of tort of negligence consist in duty of care. Duty is owed to the plaintiff. There is not even pleading. This is what the learned judge has observed. That duty is owed to the plaintiff. That duty has been carelessly breached. Now kindly see the next sentence. Negligence does not entail liability unless the law exacts a duty in the given circumstances to observe care. Duty is an obligation recognized by law to avoid conduct fraught with unreasonable risk of damage to others. The question whether duty exists in a particular situation involves determination of law, which the learned has found. On law, the learned judge has found that I have no such duty. Law, no, my lord, the breach of duty causes damage, and how much is the damage should be comprehended by defendant. Remoteness is relevant, and compensation and proof thereof requires consideration. The element of carelessness in the breach of duty and those duties towards the plaintiff are important components in the tort of negligence. Negligence would mean careless conduct in the commission and omission of an act connoting duty. Breach and damage therefore suffered by the person to whom the plaintiff owes. Duty of care is therefore crucial to understand the nature and scope of the tort of negligence. Duty of care, there is not even pleading because he knows. I don't owe any duty of care to him. Would your lordship will now kindly see the very next paragraph, 11, existum. What emerges is that in addition to, my lord, in addition to the foreseeability of damage, necessary ingredients in any situation giving rise to a duty of care, or that there should exist between the party owing the duty and the party to whom it is owed, a relationship characterized by the law as one of proximity, or neighborhood, and that situation should be one in which the court considers it fair, just, and reasonable that the law should impose a duty of a given scope upon one party for the benefit of other. Now kindly see, my lord, the very next page, just 3 lines, my lord, page 579. The question is of intensely pragmatic character, well suited for gradual development, but required most careful analysis. The following requirement must be satisfied: foreseeability of damage, sufficiently proximate relationship between parties, and even where 1 and 2 are satisfied, it must be just and reasonable to impose such duty. My cargo was for Haldia petrochemicals. I have come to discharge in Calcutta port. And he is not the owner of any of this. He is the operator. And he is, as an operator, based on his purported contract with other party, with I have nothing to do with HPCL.
Owner of the twin arms.
Yes. I'm sorry?
He's the owner of the twin arms.
Yes, owner of the arms, correct.
Arms were damaged here.
Correct. So, my lord, so far as arms is concerned, I have secured. Damage to arms is concerned, I am secured.
So his other claim is also pertaining to the arms.
No, true.
It's a different question whether he has been able to establish or not.
That is why, my lord, where the learned judges, my lord, I'll pass it on to my lord, the English judgment on Spartan steel, they have said there can be no economic loss covered. Because on foreseeability test, there is a limit. Because how will I, my lord, any person, his contract, suppose he says, the pipe will come after 5 years. I'm supposed to secure for 5 years. My lord, ultimately, your lordship will have to test in abstract. Here it is 1 year. Let us say he said, no, this is such an equipment which is going to come, which is going to take 10 years. So for 10 years, I will pay this. And that is why, my lord, I showed it to your lordship on both points. On quantum, because it is a case of no loss. It is clearly possible. In 1 year, it is possible in one of those days, 2 ships might come. But then it was onus was on them to show this. They have not shown even a single day that there are 2 ships. They are simply claiming, this is damage, my contract, 10 months, so give me. Blood. No, would your lordship will kindly see which the learned judge has Spartan steel.
These judgments were probably referred to before the learned judge also.
I'm sorry?
These judgments were considered by the learned judge also.
This judgment was the one which I just shown it to you was not pointed out to the learned judge.
But the judgments which are considered in this judgment, those were considered probably because foreseeability
is there. Spartan steel is yes. You got Spartan steel? Yeah. Okay. Now, kindly see, my lord, Spartan steel at 34, my lord. You know, all these English judgment, the biggest problem is they have with the placitum. They don't have para numbers. Would your lordship will kindly see at page 34. Page 34A. My lord, Lord Denning, my lord. And you?
Yes, yes, got it. Yes.
Oh, sorry. You want copy? Yeah. Yeah, 1 minute. You got copy, right? Yeah. Please. Thank you. Kindly see, my lord, at page 34, this is a Denning judgment, my lord. Plaintiffs have a factory in Birmingham where they manufacture stainless steel. The factory obtains electricity by a direct cable from power station and Midlands Electricity Board. In June 69, the defendant contractors were doing work on a road about a quarter mile away. They were going to dig up the road with a big power-driven excavating shovel. They made inquiries about the place of the cables, mains, and so forth under the road. They were given plans showing them, but unfortunately, their men did not take reasonable care. The shovel damaged the cable which supplied electricity to the plaintiff's works. The electricity board shut down the power while they mended the cable. The factory was at that time working continuously for 24 hours all round the clock. The electric power was shut off at 7:40 p.m. on 12th June and was off for 14.5 hours until it was restored at 10 a.m. on June 1369. This was all through the night and a couple of hours more. But as this factory was doing night work, it suffered loss. At the time when the power was shut off, there was an arc furnace in which metal was being melted in order to be converted into ingots. Electric power was needed throughout in order to maintain the temperature and melt the metal. When the power failed, there was a danger that the metal might solidify in the furnace and do damage to the lining of the furnace. So the plaintiff used oxygen to melt the material and poured it from a tap out of the furnace. But this meant that the melted material was of much less value. The physical damage was assessed at 368 pounds. In addition, if that particular melt had been properly completed, the plaintiffs would have made a profit on it at 400 pounds. Furthermore, during this 14.5 hours, when the power was cut off, the plaintiffs would have been able to put 4 more belts through the furnace, and by being unable to do so, they lost the profit of 1767. This 1767, the court said you cannot get it. The plaintiffs claim all the sum as damages against the contractors for negligence. No evidence was given at the trial because the defendants admitted they had been negligent. The contest was solely on the account of damages. The defendants take their stand on so and so, so and so. They admit they are liable for 368 physical damages. They did not greatly dispute that they are also liable for 400 loss of profit in the first melt because that was truly consequential on the physical damages and thus covered by SEM so and so, so and so. But they deny that they are liable for 1767 for other 4 melts. They say that was economic loss for which they are not liable. The single judge rejected, so this came in appeal. Now your lordship will kindly see at page 36D, my lord, page 36D. Placidum D at page 36.
Yes.
At bottom, I think the question of recovering economic loss is one of policy. Whenever the courts draw a line to mark out the bounds of duty, they do it as a matter of policy so as to limit the responsibility of the defendant. Whenever the court set bounds to damages recoverable, saying that they are or are not too remote, they do it as a matter of policy so as to limit the liability of the defendant. In many cases where economic loss has been held not to be recoverable, it has been put on the ground that the defendant was under no duty to the plaintiff. Thus, where a person is injured in a road accident by negligence of another, the negligent driver owes duty to the injured man himself, but he owes no duty to the servant of the injured man. Kindly see the lordship, the distinction. Servant of the injured man, nor to the master of the injured man, nor to anyone else who suffers loss because he had a contract with the injured man, nor indeed to anyone.
Yeah, Mr. Rambadan, they're not claiming for HPCL, they're claiming for themselves.
Economic loss. No.
I mean, apart from Lord Denning aspect of it, I mean, because it's Lord Denning.
No.
So, Mr. Rambadan,
I am a great fan of Dan Muller. That's
yes,
that's
Lord
fair
Denning's
enough.
statement is there. He was
No, Lord.
Anyway.
My lord, as my my lord, see, my lord, as I
Mr. Rambadan, you're right. There has to be a proximity. There has to be a nexus between the alleged.
foreseeability test.
Definitely, foreseeability has to be there.
My lord, the learned judge.
Definitely, you're right on that.
The learned judge on all counts held in my favor. Kindly see, my lord. Today, what is that suddenly we found in this court, but the other side has put in to reverse that? Because, my lord, your lordship will kindly see. And, my lord, as I pointed out, I am still making my strongest submission that they have suffered no loss. My lord, this point on law is in my alternative. I don't want to pitch on the point of law alone. So, my lord, there is no question of Videsh that Capitan put judgment. If I have satisfied your lordship, ultimately your lordship will have to satisfy my lord. If your lordship's conscience is satisfied that they have suffered no loss, and they could have easily shown by bringing the invoice of October, that would have been, and that has been suppressed because it will be the same amount. November, today is 2nd November, it will be the same amount. So, my lord, they are trying, my lord, what is happening in this court, my lord? The litigants somehow, I feel, are making use of let me take maximum. I must tell your lordship, where my learned friend Mr. Thakkar is assisting in one of the matters before the single judge. Suit of 1996. 1996, it is 27 years. The defendant, the plaintiff put up guarantee and took away my cargo, and that's it. I am holding with the baby. Bank guarantee, I am secured. What do I do? 27 years. This exactly they want to extract. Get 30 crores, 40 crores, 80 crores. What else to do? The foreign owners, okay, chalo, yeah, what do you want? You want 20 crores? You want 20? We will not succumb to that. We will not succumb to that. This is nothing but blackmailing tactics. This is not a case of genuine loss. Which manufacturing, I said that is fine. Cost of thing, as your lordship again said, double up, without prejudice to my, since I'm sure your lordship will keep the appeal open.
Definitely.
Yes. So, my lord, we will argue at that time. But ship can sail by doubling up. So, my lord, this and my lord, and my lord, kindly just Wander's judgment, because Wander's judgment, even now, until now, Wander's judgment, my lord, just give. Other side, other side, other side. My lord, para 14.
Yes.
The appeals before the division bench were exercise of discretion by the single judge. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily, capriciously, perversely, or where the court had ignored the settled principles of law regulating grant or refusal of interlocutory injunction.
Too well settled, Mr. Ram. Too well settled.
I'm sorry?
Too well settled.
Yes. Well,
Obviously, yes, definitely. More so in intra-court appeals. More so, no, you're right. More so in intra-court appeals. You're absolutely right.
I am not for a.
Definitely,
This is my pardon, my lord. This is not for a moment. Some of these are well-known principles, my lord.
Nothing personal at all. You're right. But this is too well settled. I mean.
My lord. And this is in the latest judgment, the same thing, my lord. Despite this court reversed, and the Supreme Court has again come down heavily. This court, well, latest judgment, just get Punjab and Sindh. Other side, other side, other side. Look, this matter latest again went from Calcutta. This is the latest. Your lordship will kindly see para 26. Wander is quoted. Then, my lord, Wander is quoted. Para 26. Then kindly see, my lord, para 27. It has been held by this court that the appellate court would not interfere with the exercise of discretion of the court of first instance and substitute its own discretion, except where the discretion has been shown so and so and so, arbitrarily, capriciously, or perversely, or the court had ignored it. It has been held that appeal against except is said to be an appeal on principle. It has been further held that the appeal court will not reassess the material and seek to reach a conclusion different from one reached by the court below if the one reached by that court was reasonably possible on the material. It has been held that even if the discretion has been exercised by the trial court reasonably and in a judicial manner, that the fact that the appellate court would have taken a different view may not justify interference with the trial court exercise discretion.
We'll hold Mr. Rambhadran that it has been held in this judgment, that it has been held in the previous one, that has been held, that this proposition is there. But the proposition remains the same. It's a very well settled proposition, still remains a very well settled proposition. And you are absolutely justified in arguing this. This proposition is right. Yes.
My lord, last I was pointing out, I don't want to really emphasize on that, but my lord, under the commercial court, the appeal is not.
Yes.
Would your lordship will kindly see for a minute?
Commercial court check nahi hai.
Page 13. Sorry, section 13.
Section 13, yes. Commercial court check taken. No, this is not a regular bench. Actually, this is a vacation bench, so we are not equipped with all the books. I should have been prepared with my tab. Actually.
One more. Yes. One more. You got one more copy?
Yes.
No, commercial. Commercial.
Yes. Section 13, yes. Proviso?
Yes. Provided an appeal shall lie from such orders passed by the commercial division or a commercial court that are specifically enumerated under Order 43 of the Code of Civil Procedure as amended by this Act and Section 37 of the arbitration, and we are not concerned with that.
Yes.
Yes. So, my lord, if you lordship will see 43. This is under 43.
39.4.
No, 39.4. I can come. He can come.
If it's rejected.
Yes, no. Correct. Your lordship will kindly see under Order 43. As my lord with CPC. CPC.
What are they? Yes.
Your Lordship will kindly see
Yes.
straight on to
R.
R 1 2 of order 39. Yes, that I can
An
come.
order under. An order under order 39
Yes.
rule 4.
Because
Not a rejection or an allowing.
no, it will not. It will not.
Your application was for vacating or modification.
Modification.
Which was under order 39 rule 4.
Yes.
Therefore, the impugned order is an order passed under order 39 rule 1 and 4. So it's very much appealable. I was wondering yesterday whether we were going somewhere wrong. I mean,
No, my lord. Would your Lordship will kindly see
your CPC is the same as mine. Mr. Rambhadan, it's very clear, an order under, not an order of refusal there. In some cases, definitely order 9 rule 13, order 9 rule 9, their refusal is appealable. They review the opposite.
Lord,
But in order 13 rule for any order.
no, no. Well, Lord, I don't know. If your Lordship will kindly see for a minute in the left hand side, JA, where it says an order rejecting an application. This is a case of an order rejecting an my lord.
I think actually our books are different.
I'm sorry?
I think actually our books are different. After the amendment, probably this is the pre-amendment. I think so. এই বইটা ফেরত দিন।
Yes, this is after the amendment for 39.
No, what are, I don't understand. I mean, R.
No, I'm on J.
J is something.
JA.
J is order 21.
No, correct. I'm pointing out your Lordship only to the language. There it says an order rejecting an application.
Yes.
It is not that every order is directly applicable. If according to them that if an order not
You're serious, Mr. Rambhadan?
Sorry?
You're seriously arguing this? If you're seriously arguing this, please check your facts first.
Very well.
Probably there is some misunderstanding.
Lord,
This appeal has been preferred against order 39 rule 4 and order passed under order 39 rule 4, which is appealable. Any order under order 39 rule 4 is appealable, Mr. Rambhadan, under order 43 rule 1 R.
No, my lord is reading under R.
R.
So it says 1, 2,
An order,
4.
An order under rule 1, rule 2 capital A, rule 4, or rule 10 of order 39.
But this is actually an order under 38.5.
No. The interim order here is not an order under order 39 rule 5. You filed an application under order 39 rule 4 for vacating an order which was passed under order 38 rule 5.
Yes, my lord, yes, your lordship is right. But the original order is under 38.5.
Original order does not matter. Nobody is challenging the original order or order 38 rule 5.
Right.
The present challenge has been preferred against an order 39 rule 4 order. Any order passed under that provision, Mr. Rambhadan, is appealable under order 40 rule 1 R.
Very well.
I think let us not.
Very well. Let me raise this at some
other at least some other court.
Yeah, no, not that way. Then I also need to.
No, Mr. Rambhadan, no. So let us hear the other side now.
Just the last point first. May I just put to rest? My lord will kindly take the Admiralty Act once, section 14.
Commercial Court Act owner. It is Mr. Rambhadan difference. Yes.
May I just place it and hand over the book?
No, you have handed over a book.
No, I'll hand over one. I don't give
Oh, no, yes.
Notwithstanding anything.
This is which section?
This is section 14 of the Admiralty Act
Right.
of 2017.
Yes.
Notwithstanding anything contained in any law for the time being in force, an appeal shall lie from any judgment on final order or interim order of a single judge of the High Court under the Act to the divisions of the High Court. This I didn't want to get into that. I know what your lordship has said, but this even that.
Come to the main points, Mr. Banerjee.
Huh? Yeah,
Come to the
on
main-
merit, on merit. May I just come back to
Yes.
But first thing, not first, I say is there are two arms. Two. One is HJ1, HOJ1, one is HOJ2. But first question that I ask myself, is that a prudent businessman, if he can do with only one twin arm, why would he require another an HOJ2? Or HOJ1 is there, so HOJ, so one would sufficient. There has to be a specific reason why HOJ1, there was one, somebody will have one twin arm in HOJ1, somebody will have, it is a prudent business decision. Look, my first thing that I when I ask this question, the situation is this. A river, this is a river port with the jetties are there. Each of these jetties have about 4 or 5 different companies own different these arms. When one particular jetty has one arm is being used of some company or the other, at that point of time, that jetty cannot be used by anybody else. There are 4 arms on that jetty, but one arm at a time can be used. So today, if anything happens in HOJ1, any other of the companies are occupying HOJ1, then no vessel of mine can come to HOJ1. Then HOJ2 I put to use. When HOJ2 is there, then it's not how much time I take or simultaneously both vessels coming in. It is if any of the 4 companies, 4 arm owning companies, if any of their vessels are there, then I can't use that particular jetty. I have to go to the next jetty. Otherwise, I can't do it. And that is the reason why Haldia port authorities have said that you can't come to HO1. We are transferring. HBCL has said that we are going to other ports because they can't wait. So today, it is not that I have to have 2 vessels coming. What my learned friend said, I have to have 2 vessels coming in simultaneously, then only HOJ1, HOJ port. It is not a matter of simultaneous. It is matter of that the availability of that particular jetty, because those arms, any one of the companies using any one arm, I will paralyze the rest, my other part.
We are not clear on this point, Mr. Banerjee.
I'll tell you that once again. This is one jetty. This is another jetty. In one jetty,
these are the 2 arms. Suppose the 2 microphones.
No, these are 2 separate jetties. I'm saying. Now, in each jetty, there are 4 separate companies have 4 separate arms.
One of which is yours.
One of which is mine.
Yes.
Now, this is another. This may be 4 separate.
They are also similar.
They are also similar. This is another thing. Now, if a vessel comes in and say company X is where one is being loaded or unloaded, once one particular vessel comes over here, then the other 3 arms becomes redundant. No other vessel, because in that particular jetty, only one can happen.
Right.
So any vessel coming in of mine, it has to go to this particular jetty. This particular jetty. Then because, so similarly, it is not that I have to have 2 vessels of mine coming into the 2 jetties simultaneously.
So at any given point of time, you have to have both available so that it can be accommodated.
One has to be available in any one of the jetties.
Yes.
Because in one, it is not only mine. It is 4 of those arms.
This case is not made out anywhere in your application or plaint.
This entire argument was not there in the vacating. I did not say a word.
No,
but this is a factual aspect which I don't think my learned friend will dispute this. That because my learned friend made this submission that today I have to have 2 vessels coming in, and therefore only I will require HOJ1 or HOJ2. Otherwise, I don't require. That is not correct. I'll have even 1 vessel coming in. But if other companies are using any one of the other 3 arms are being used, I will not have any place to put in that particular jetty. I'll have to go to the other jetty. Because each of them have separate jetty. The jetty can accommodate only one at a time.
Mr. Banerjee, how long does it take to for this unloading and loading?
36 to 48 hours. Per vessel. Let's just give me 1 minute. I'll just find out.
2 days. 2 to 3
2 to 3 days for one.
So the vessel can wait during that period?
No. So today my turn will come in. So 2 to 3 days. Then next is another 2 to 3 days. Then next is another 2 to 3 days. And next is another 2 to 3 days. So there are 4 arms there. So 4 3 are 12 days I have to wait. When the vessel comes in, then today if he does not, he has to turn about time. Because he has to pay port charges. So today he will like to come, deliver, go as soon as possible. So today, each of those, that is why, not why did my client, why a prudent businessman would invest? These are all expensive and very technical equipment. Why would he invest in having two? Because simple reason is he knows that the turnaround time of this, if because it's not just my thing, it is 3 days, 3 days, 3 days, 3 days. So my turn will come even after, say, possibly 12 days or 15 days that my turn will come. That is why, my lord, what happens is, if my lord sees, my lord, in my lord, I have annexed it at page 710 of volume 5.
This is new document.
Yeah, absolutely. He also relied on the new document. I'm just saying it very well.
No,
Why
this
did
was
you
not
rely
in
on new
the
document?
at the juncture of the vacating application. This was
no, it was not.
no. He's relying on his vacating application document.
Very good. Then, very well. Your Lordship not look at those documents. I'll just tell your Lordship. Over there, so basically what happens is 3 or 4 vessels can come in. Because 12, but one can come in here, one can come in. So that way, only in a month, generally I get 3 or 4 vessels at a time. In these, if your Lordship looks at the HOJ1. So therefore, it is not what I have said. What have I based my claim on? I base my claim on the total volume which ultimately. I am not honestly, Miller, getting into the GST part. I am not even going to waste your Lordship's time. I am not wasting your Lordship's time on the bottling part, because that, if your Lordship sees my written notes of argument, I am told, Miller, before the trial court, it was argued that we have given up the bottling part. So the GST, and also I'm saying this, GST is not, Miller, an attachment, but GST and bottling apart, if your Lordship segregates those two, then this is, Lord, yesterday a submission was made, Lord, that they are talking about the volume of business, the total number of invoice. Lord, my humble submission is this. Again, Lord, I say bottling and the apart. The rest, it is not just loss of profit. I'm saying loss of business. Because lots of profit is only a, Lord, end of the day, today, if my particular arm is not used, then the fixed costs which are there, that I in any case incur. That I will incur. If literally I am not able to deliver, my fixed costs, I cannot, for 1 year, I cannot stop all my fixed costs. So today it is not a matter of net profit of what I've lost, which my learned friends say that why should the invoice be taken into consideration? Because this invoice is not the profit. No, I'm not saying profit. I'm saying that it has to be taken into consideration, because the simple reason is that because during this period, the fixed cost which I have, that in any case I incur if I don't use it. So that is why, I say that, therefore it is very germane to the quantum of business that I've undertaken. I fully bow down to exclusion of GST. I fully bow down to exclusion of bottling. Those things I'm not getting into. But other than that, Millard, I am entitled to the full thing. Next, Millard, I would like to Millard, a lot of emphasis was paid on that Spartan Steel judgment. Millard, may I say this? Spartan Steel, what has happened? Millard, the electricity, I'm not deliberately going to paragraphs because I know Millard, time is a factor. Spartan Steel, what happens over there is that the electricity was disconnected. The ingots got damaged. The furnace did not get damaged. The court held that the furnace was damaged. So you could not claim damages for the furnace, because the furnace was, the court granted for the ingots, but not for the furnace, because the furnace was not damaged. Over here, my arm is damaged. I'm saying that my arm can't be put to use. The furnace could have been put to use. The court did not grant Spartan Steel for the furnace because simple reason that furnace was not damaged.
Right. Sorry, my lord, that is not correct. Because what is not granted is, what they said was, during the period when it is cut off, I could have made 4 more. That is economic loss. Nothing to do with furnace. Because the electric supply was cut, the manufacturer claimed during this period, I would have made 4 more ingots. I want to make, so the court said that is fails under the foreseeability test. And just, my lord, since I interrupted already, just only one thing, my lord.
This is a new thing
the invoice, my lord, it is refers to the rate, and they have produced agreement. I checked 20 times. Nowhere the rate is mentioned in the agreement. No rate. And the rate is not even mentioned in the agreement. Then just one more. He is not only doing for, this is for, this arms is used only for propane and butane. That is their case. All other cargo discharged directly to jetty. Now kindly your lordship will kindly tell me, if I want to see, is this invoice is for only for propane and butane, or this invoice is for all? How do we make all this?
Let's hear him, Mr. Ram.
Yes.
Yes, please go on.
Again, my lord, I repeat what I said, my lord, that the court did not grant for the furnace part of it. Next, four. What was my lord, so as far as that part, that will not, there no, and this case that two vessels have to come in together, this is not in the vacating application. This was never argued before the court. My lord, my entire thing has been that this is the amount today. It is difficult for me to segregate at that urgent stage, for me to segregate exactly what was for HOJ1, what was for HOJ. Today, admittedly, my lord, today I have suffered loss. It is nobody's case that then my arm is not damaged. Today, admittedly, I cannot put it to use. Now, for how long I cannot put it to use? My learned friend said that only 7 months. I said not 7 months, it's 8 months period. From November to July is 8 month period. That is the time. That is the time when the manufacturer takes. Today, has he shown that this particular thing is available in the market and I can buy it off the shelf? No. Nobody's case is that. Today, Lord, it is not his case that how much time it takes. Today, I have given the order period where I have shown that it is about 8 months for it to be manufactured. Number one. Number two is thereafter is the installation. And by the time it becomes functional, it is a year's time. So it is 8 months, true, but thereafter installation and functional, it will take about 1 year. And on the basis of that, I have said, now another thing, what happens, Lord? These vessels come in once to HOJ1, HOJ2. Thereafter, as I explained to you, the entire process, the throughput from the time these ducts go into the vessels and right through, then tank, and thereafter it is going through the ultimately tank, mixer, and then out to the tankers, the vessel, the vehicle which takes it away, the tankers. This entire function. Today I have 2 arms for facilitating. Why? Because they will expedite the entire process of this. And I am not paid for vessel wise. I am paid on the basis that how many vessels, how many tankers I am able to provide to HPCL. What are there? So today, whatever I do, so today, your lordship will kindly consider one thing: admitted position, damage has occurred. They don't, whether it is, I don't put it there that they are, I am saying it cannot be replaced and a new machine has been put. I have said, the manufacturer has said this. Today, joint surveyor has said that cannot be put to cargo operation. So in that case, a new installation has to be made. If the new installation is made, manufacturer said it's taking only 8 months. Thereafter installation, and thereafter, once it has happened, it's about a year's time. This entire time, I lose out on business. So for that reason, I have said the total business that I have to do, because it is my entire invoice and everything is in one basis, because Hindustan Petroleum does not give me on vessel wise, they give me on the ultimate output that comes out and goes to, which is through the ultimate tank. So that's why the invoices are all together jointly. So it comes out that way. So these are my humble submissions. Anything else?
Appeal needs to be heard. So state will be
so, and last and foremost, I would like to say that today, ultimately, once they go away, my decree will become a paper decree. I am not saying that I have any right. I am not for a moment one of those who say that they should be held to, under a gun, duress, threat, blackmail, nothing. But what your lordship will think
is a logical figure for the damage that I have suffered. I have said that this is going to be, this is the loss, this is the equipment which the London judges said, well, so I'm not going into this. And this is the loss of business that I'm going to suffer. So which I've said, look, today I have to suffer some loss of business. So as far as that is concerned, the London judge has not given me anything, it's zero. So I have to get something on top of that. Now, what, according to your lordships, will be that something? Will it be the figure I've asked for? What is should be what the basic? Nobody is here over here, not going into the particulars, claims, and everything. That will not. I have to prove everything. Everything will be done as the truth. But what your lordship thinks is a reasonable amount for protecting me when I will not get the decree. That is the amount of security which your lordship will detect.
Achha, both of you have argued extensively. I mean, we indicated clearly that we are hearing it on the interlocutory orders. So we'll be deciding whether we will pass interlocutory orders now. We'll keep the appeal alive.
That is for your lordship. Your lordship, because we have argued so much.
No, it depends on you. If both of you agree either way, we'll do that. I mean, we have heard extensively. Either we dispose of the appeal or we dispose of the prayer for interlocutory order. Whatever you say, both of you. You can look at us to read our minds.
I'm sorry.
You can look at us to read our minds so that you can decide on that whether which way we'll go. But either way, I mean, we'll pass our orders today itself. We have to pass because we don't have this bench before the vacation reopens. The court reopens. So we'll have to pass it today. So either way, we'll be indicating either the interlocutory order. Either way, I mean, whichever way we go, probably the appeal itself will be affected.
Because I'll tell you, lordship, today, if your lordship is against me, I don't think it's very unlikely.
Yes, we are on that.
So, 10 minutes today, my entire appeal will become infructuous if the vessel goes in.
Yes, if you don't grant the interim order, then your appeal becomes infructuous.
That's it.
So it tantamounts to the dismissal of the appeal.
Yes. So your lordship, it's better your lordship hears it out and
What about the other aspect of the matter? Suppose if you grant you stay, then that depends on Mr. Rambhadan. He also has to decide. Then also probably the same. I mean,
I'm sure I'll tell you, lordship, in this jurisdiction, possibly nobody can wait in any court. They are not going to wait for that.
No, even if suppose if you grant that stay, we go against you, Mr. Rambhadan, then also the effect is the same because the appeal will be the main application will be heard before the regular bench.
I'm sorry.
Suppose if we grant the interim order which is paid for by Mr. Banerjee, then also the effect is allowing the appeal in. I mean, for
there are two aspects as your lordship says. One is I'm greatly affected by the quantum.
No, your points regarding your arguments, we are not. This is not any comment on your arguments at all. No. About you decide whether we decide the appeal today or pass interim orders because we are prepared for both.
I would think, possibly because today I'm sure, even when I say this, and I don't think I'll be very unfair when I say this. If he is aggrieved, he will go up a higher forum.
That is that definitely. So this matter, the stakes are too high for not doing that.
Yes, so that's
either
why,
way. Either
therefore, anyway, any of our suffering will have to go up. So this appeal will become infructuous. So your lordship,
because the appeal in the appeal, the difficulty is in appeal. No further documents are required. Whatever documents are there. We cannot improve on the documents.
No, we made an application for inclusion of further documents.
You have made an application.
Yes. Order 41/27, then application is there.
That is not, my lord, I will point out the judgment of the Supreme Court. They have been now formed after the Commercial Courts Act that if...
Anyway, then we decide on the appeal of the interlocutory order, whatever way.
Power is there to, with the leave of the court, additional documents can be produced under the commission.
So, my lord, I am only on the, whether, my lord, on a point of law, on the foreseeable test, I'm, that is what is, whether it is my lord, we have fully argued. That is, there has been time constraint.
We'll decide the interlocutory order. আমি অর্ডারটা পাস করে দিচ্ছি এখানে পাস শেষ করে দিই The present appeal একটু বড় হবে দুজন মিলে নিতে হবে। The present appeal arises out of
My lord, may only 2
Yes.
minutes. I'll just ask my client and come back, my lord.
do that.
About this.
We are starting with the order.
Yes,
We'll
yes,
morally tie the
just 2 minutes, my lord.
absolutely. You do that. We'll in the meantime we'll proceed with the order.
Yes.
এটা কোথায়? হ্যাঁ, arises out of an order dated October 19, 2023, whereby the learned single judge modified an order dated September 15, 2023, granting no, Mr. Banerjee, where do we find the order of Justice Mukherjee?
Arindam Mukherjee.
Yes.
My lord, page 206. কোন volume ওটা? Volume 2.
Volume 2 টা কোনটা?
Page 206.
Thank you.
Has your lordship got one?
Yes, yes,
Give
yes,
my
yes.
copy, if your lordship.
Whereby বলেছি? Whereby এর পর থেকে বাকিটা কেটে দিন। Whereby the concerned vessel TSM Pollux POLLUX within bracket IMO number 9266889 bracket closed along with a tackle hull engine equipment apparels furniture and all movables lying on board was directed to be arrested forthwith. Full stop. The said order was to continue unconditionally till September 27, 2023. Full stop. If in the meantime, the plaintiff filed an undertaking in terms of section 11 of the Admiralty within bracket jurisdiction and settlement of maritime claims bracket close Act 2017 to the effect as envisaged therein, the order of arrest was to continue until further orders. Full stop. Next para, it may be mentioned that the plaintiff has complied with such direction by filing the said undertaking. Full stop. It was further clarified in the order dated September 15, 2023 that in the event the dependent deposits an aggregate amount of USD 506,161 and rupees 84,00,67,559 in the suit as security with the registrars, original side of this court, the order of arrest of the vessel shall stand automatically vacated. Full stop. Next para. By the order impugned in the present appeal dated October 19, 2023, the learned single judge directed the defendant to deposit only rupees 4,70,70,265.93 as security with the registrar, original side of this court, instead of the total amount as directed with the order dated September 15, 2023. Full stop. Next para. Learned senior counsel appearing for the petitioner contends primarily that the learned single judge, while passing the impugned order dated October 19, 2023, proceeded on an erroneous premise that আমার এটা কোথায় গেল? হ্যাঁ, None material, please.
Lordship may dispose of the appeal.
Thank you. Good. That the only documents disclosed were invoices raised by the petitioner, by the appellant, on account of bottling and throughput charges, but the plaintiff had not disclosed any agreement with HPCL, and the invoices disclosed do not refer to any particular berth, for example, HOJ Roman 1 or HOJ Roman 2. Full stop. Next para. It was further observed that the entire projected loss of income for 1 year consequential to the damage of the loading stroke unloading arm of HOJI, Roman 1, where the accident occurred is based on unsubstantiated figures. Full stop. The learned single judge further observed that the plaintiff does not plead duty of care owed by the applicant owner to the plaintiff, and the pleadings in the plaint suggest that the defendant was discharging cargo for HPCL, which is incorrect. Full stop. Next para. Despite observing that a claim for compensation or damages would have to meet the standard test of a reasonably best arguable case at the interim stage, the learned single judge observed that the plaintiff had not been able to substantiate its claim for business losses. Full stop. Next para. Learned senior counsel for the appellant places reliance on the averments made in the plaint as well as the documents annexed thereto, which included several invoices for a period of 1 year immediately prior to the claim being made. Full stop. It is argued that the said invoices clearly shows the income earned by the appellant from the business which was being done by the appellant by operation of the two twin arms, of the petition, of the appellant in HOJ1 and HOJ2 respectively. Full stop. Next para. It is required to be clarified here that HOJ Roman 1 refers to Haldia Oil Jetty Roman 1 and HOJ2 TO2 Haldia Oil Jetty Port 2 respectively. Full stop. Next para. Thus, it is argued that the plaintiff sufficiently substantiated its claim for damages on account of business loss for the projected period of 1 year, which would be the requisite period for replacing the arm which was broken due to alleged negligence of the defendant. Full stop. Next para. It is argued that the plaintiff also substantiated the case of damage insofar as it is an admitted position that the vessel of the defendant was plying in the said port at the relevant juncture and it was going to unload its cargo at HOJ1. Full stop. Next para. While so plying, the crane, the boom, BWM, of the crane on board the vessel of the defendant was kept in an obtuse angle and not in a right angle, properly parked on the said vessel. Full stop. Due to such utter negligence of the defendant, it is argued, the one of the arms at HOJ Roman 1 was damaged beyond repair. Full stop. Learned senior counsel for the plaintiff stroke appellant also places reliance on a report given by the manufacturer of the said arm to substantiate his claim that the said arm cannot be repaired but has to be replaced. Full stop. The entire process, it is argued, shall take about 1 year, which is also substantiated from such report. Full stop. In fact, comma, when the arm which has been damaged was initially procured, comma, the total time taken for transport and installation of the same was more than 7/8 months. Full stop, next para. Learned Senior Counsel argues that, comma, thus, comma, the premise on which the impugned order was passed is palpably erroneous, comma, since the learned single judge did not take into account the substantial pleadings and materials in the plaint and annexed to the plaint of the appellant, comma, which bolstered the claim of the plaintiff. To stop that apart, comma, it is argued that the learned single judge also proceeded on the premise that there were three births, BERTHS. Full stop. However, comma, it is an admitted position that the plaintiff only has a pair of twin arms at HOJ Roman I and HOJ 2, and there is no third arm, comma, which was also one of the premises of the impugned judgment. Full stop. Next para. It is argued by learned senior counsel appearing for the appellant, comma, by placing reliance on the judgment of Vora Sadiq Bhai, এটা একটু দেখে নামটা করে দেবেন, reported at 2016-12 SCC 1. That in a nutshell, comma, what needs to be examined is as to whether the damage to the property of the appellant was the result of an inevitable accident or unavoidable accident which could not possibly be prevented by the exercise of ordinary care, comma, caution and skill. That is, it was an accident physically unavoidable. Full stop. Next para.
Paragraph 15 minutes.
29 also is.
Yes, 29, but paragraph 15 also is.
Very well. In paragraph 15 of the said judgment, comma, it was observed, comma, by relying on Rylands versus Fletcher, comma, that the true rule of law is that the person who, comma, for his own purpose, comma, brings on his land and collects and keeps there anything likely to do mischief if it escapes, comma, must keep it in at his peril, semicolon, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. Full stop. Next para. It was further observed that the general rule as stated above seems on principle just. Full stop. Next para. It was also observed that where a wrong has been committed, comma, the wrongdoer must suffer from the impossibility of accurately ascertaining the amount of damages. Full stop. Next para. Learned senior counsel further places reliance on Videsh Sanchar Nigam versus MV Kapitan, এটা নামটা দেখে করবেন, reported at 1996 7 SCC 127. Full stop. In the said judgment, comma, it was entirely observed that the admiralty action is an action in rem. Full stop. In the said case, comma, the division bench found that the claim was not vexatious but is triable. Full stop. Next para. There was strong evidence to show that at the relevant time, the respondent vessel was within the vicinity of the damaged cable. Full stop. Next para. The court went on to observe that the ship is a foreign ship, and if it leaves the shores of Indian territorial waters, it is difficult to get hold of it and it may not return to the jurisdiction of Indian courts. Full stop. The claim thereby, even if successful, comma, would remain unexecutable or land in trouble in private international law in its enforcement. Full stop. Under such circumstances, comma, the court proceeded to form the opinion that the vessel may be released on certain conditions of payment of certain sums of money. Full stop. It is argued that the same principle ought to be imported in the present case. Full stop. Since the plaintiff has made out a sufficiently arguable case for damages by way of business loss, comma, there was no justifiable reason to deny the plaintiff of such relief by the impugned order. Full stop. Next para. Learned counsel appearing for the respondents places reliance on Spartan Steel and Alloys Limited versus Martin and Company within bracket contractors limited. Full stop. In the said judgment, comma, it was observed by the Court of Appeal, comma, that in the said case, the plaintiffs had a factory in Birmingham where they manufactured stainless steel, which obtained its electricity by a direct cable from a power station of the Midlands Electricity Board. Full stop. There was a massive power disconnection for which damages were claimed by the plaintiffs. Full stop. Such damages against the contractors were claimed on the ground of negligence. Full stop. No evidence was given at the trial. Full stop. It was observed that the question of recovering economic loss is one of policy. So whenever the courts draw a line to mark out the bounds of duty to italics, comma, they do it as matter of policy so as to limit the responsibility of the defendant. Full stop. Whenever the courts set bounds to the damages to italics, recoverable hyphen, saying that they are, comma, or are not, comma, too remote, hyphen, they do it as a matter of policy so as to limit the liability of the defendant. Full stop. Next para. By taking a cue from the judgment of Managing Director, comma, Kerala Tourism, reported at 2019-16 SCC 573, comma, Learned Counsel highlights that negligence as a tort is the breach of a duty caused by omission to do something which a reasonable man would do, comma, or doing something which a prudent and reasonable man would not do. Full stop. The elements of tort of negligence consist in hyphen small a within bracket duty of care semicolon small b bracket duty is owed OWED to the plaintiff semicolon small c bracket the duty has been carelessly breached, full stop. Negligence, comma, it was observed, comma, does not entail liability unless the law exacts a duty in the given circumstances to observe care. Full stop. Duty is an obligation recognized by law to avoid conduct fraught, FRAUGHT, with unreasonable risk of damage to others. Full stop. Next para. Thus, comma, it was highlighted that essential ingredients of a claim of damages is that the following requirements must be satisfied before a duty of care is held to exist, colon, small Roman 1, foreseeability of the damage, semicolon, next para, Roman 2, a sufficiently proximate relationship between the parties, semicolon, and Roman 3, even where Roman 1 and Roman 2 are satisfied, it must be just and reasonable to impose such a duty. Push up next para. Learned Counsel also places reliance on Wonder Limited and another reported at 1990 within bracket supply bracket closed SUPP within bracket SCC 727, where it was observed that the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court has ignored the settled principles of law regulating grant or refusal of interlocutory injunctions. Full stop. In order to reiterate the same proposition, learned counsel also relies on Punjab and Sindh Bank, reported at 2023 SCC Online SC 470. Next para. Learned counsel for the respondents also seeks to distinguish the judgment cited by the appellant on facts as well as law. Next para, it is contended categorically by learned counsel for the respondents that the learned single judge was sufficiently justified in passing the impugned orders by taking note of the fact that the plaintiff had utterly failed to substantiate its claim for damages on business loss. First, it is argued, in order to ascertain the actual business losses, the plaintiff was required to produce before the court materials to substantiate its claims by segregating the same between the business done by the twin arms at HOJ Roman 1 and HOJ Roman 2. Having got sufficient opportunity, the plaintiff, it is argued, failed to do so. Rather, it is argued that from the invoices produced along with the plaint, the plaintiff stroke appellant merely indicated that certain invoices were raised by the plaintiffs for work done in respect of the jetties in general, without distinguishing between HOJ 1 and HOJ 2. It is argued that unless it was proved by the plaintiff categorically that different vessels docked in the said port and were loaded and unloaded simultaneously, the plaintiff's claim of obtaining at the damages, merely by adopting the device of dividing the total income of the plaintiff by 2, cannot be justified. Next para. By placing reliance on the documents annexed to the vacating application, learned counsel for the respondents argues that in fact the respondents have substantiated that the plaintiffs are earning substantially from the HPCL itself, in respect of which the invoices were produced, from the twin arm at HOJ 2. Hence, the plinth of the argument as to business loss is not credible. Next para, learned counsel further submits that it is the plaintiff who was all along in possession of relevant documents to indicate the exact transactions being done by the damaged twin arm and the other twin arm. Since the plaintiffs have deliberately suppressed such transactions, the learned judge, at the first instance, while passing the order of arrest, was not justified in directing the defendant to secure the damages by way of business loss as well. Hence, in the impugned order, the learned single judge, with the order dated October 19, 2023, rightly distinguished between the cost of damages with regard to the equipment, transport and installation thereof on the one hand, and business losses sought to be projected by the plaintiffs on the other. Next para. Although detailed arguments were advanced by the parties, the cardinal premise of the orders in both the instances, comma, while passing the first order of arrest and while passing the order of vacating the same, comma, remains the same. Full stop. Although the respondents have sought to hit at the root of the claim of damages of the plaintiff altogether, comma, it transpires from the plaint that sufficient proximity between the conduct stroke action of the respondent's vessel and the damages caused to the twin arm of the plaintiffs has been established prima facie. Full stop. Next para. The argument of the respondents that liability may be cast on the port authorities as well, comma, since it was the port's duty to navigate the vessel of the defendants stroke respondents properly, comma, cannot be accepted vis-a-vis the nature of the present allegations. Full stop. Next para. In the event the vessel of the defendants itself had hit the twin arm, comma, the said claim might have had some justification. Full stop. However, comma, in the present case, the boom of the crane of the defendant's vessel was jutting out apparently in an obtuse angle from above the vessel, comma, which was plying at the relevant point of time. Full stop. During motion, comma, the damage occurred. Full stop. As such, comma, primarily there is sufficient material in the pleadings and the documents produced by the plaintiff to indicate that the respondents had duty of care to castigate them in respect of damages. Full stop. Next para. Another aspect of the matter cannot be overlooked. Full stop. The challenge in the vacating application was primarily with regard to the component of business loss in the security directed to be deposited by the defendants and not the economic loss allegedly suffered by the plaintiff for damage which actually occurred to the equipment and the cost of replacing the same, comma, including transport, comma, installation, etc. Full stop. Insofar as the premise of the damages to the equipment is concerned, comma, the same cannot be distinguished from the premise of the claim for business loss. Full stop. The plinth of both the claims is the alleged negligence on the part of the defendants and the right of the plaintiff to claim damages from the defendants. Full stop. In the same breath, comma, the defendants cannot impugn the security directed to be paid by way of business loss on the premise that damage has been caused by the crane from its vessel, and in the same breath, comma, admit to the claim of economic loss suffered by the plaintiff due to the same act of damage. Full stop. Hence, comma, the said submission of the defendants regarding the very root of the duty of care and negligence cannot be accepted. Full stop. Next para. However, comma, the present issue boils down to the liability of the defendants to secure the damages claimed by way of business loss by the plaintiff. Full stop. Foreseeability, comma, as rightly argued by the defendants, comma, is an essential determinant in that regard. Full stop. Next para. A perusal of the plaint, comma, as well as the documents annexed thereto indicates that the plaintiffs only produced certain invoices for a year prior to the incident in question. Full stop. From the invoices, comma, it is seen that apart from throughput charges, comma, bottling charges and GST has also been clubbed therewith. Full stop. The defendants might have a justification in arguing that the GST component and the bottling charges could not have been claimed by the plaintiffs. Full stop. However, comma, the said challenge is a side issue, comma, since even from the invoices produced by the plaintiffs, comma, the different components for bottling, comma, throughput charges and GST component can very well be segregated, comma, thereby arriving at the actual throughput charges which were apparently earned by the plaintiff during the relevant period. Full stop. The question is not what the plaintiff could have earned during the coming 1 year from operation of the damaged twin arm. Full stop. The relevant issue here is whether actual damages or loss has been or will be suffered by the plaintiff due to the damage caused to the twin arm. Full stop. Next para. The mere possibility of damages or loss cannot be an indicator in that regard. Full stop. What the first court did at the time of passing the order of arrest was merely to club the total income earned by the petitioner, by the appellant during the relevant period and divide the same by 2 on the logic that the plaintiff has been operating 2 such twin arms and dividing the income between the 2. Full stop. However, comma, the defendants are justified in arguing that only in one circumstance could it be justified that the plaintiff lost half of its revenue due to the crippling of one of the arms, comma, the same being that vessels were being simultaneously entertained by both the arms for the purpose of loading and unloading. Full stop. Next para. An insinuation has been sought to be made by the plaintiff in this regard to the effect that at the same time, comma, if one vessel is docked for the plaintiff or for other operators in a particular jetty, comma, the plaintiff would have to wait indefinitely for loading and unloading of the vessels of the HPCL, which might have been waiting at that juncture for being loaded stroke unloaded. Full stop. It has been argued by the plaintiff that for such purpose, 2 twin arms are being operated, comma, to distribute the load between the 2. Full stop. However, comma, not an iota of pleading in that regard finds place either in the plaint or in the pleadings relating to the vacating application at any point of time. Full stop. In any event, comma, the same would be resorting to conjecture and surmise. Full stop. We say so because even if we assume that a particular vessel is blocking the jetty at the relevant point of time, comma, there is nothing to prevent both the jetties in question being blocked by different vessels at the same point of time, comma, in which case the plaintiff would then be remediless, comma, having no other twin arm to operate. Full stop. In such circumstances, comma, the plaintiff may very well have to wait indefinitely for the other vessels to move on. Full stop. That apart, comma, we do not find anything from the records to indicate as to whether the work which was being done by both the twin arms can be accomplished by the sole twin arm which is now operating due to one of the twin arms being damaged. Full stop. In such view of the matter, comma, we cannot resort to mere conjecture for the purpose of ascertaining or calculating the projected loss of the appellant. Full stop. Next para. As rightly argued by the defendant, comma, only if it was shown that simultaneously different vessels were being acted upon by both the twin arms of the defendant could the defendant claim that the total income earned by the defendant could the plaintiff claim of it? Could the plaintiff claim that the total income earned by the plaintiff should have been distributed between the 2 arms? Full stop. Moreover, there is nothing on record to indicate as to the exact transactions during the relevant period of the last 1 year with regard to the specific operations of each of the arms, which also weakens the claim of damages on business losses of the plaintiff. Full stop. Next para. Keeping in mind the scope of the Admiralty jurisdiction and the probability that a foreign vessel may leave the waters of India, thereby rendering the ultimate relief claimed by the plaintiff infructuous, even if the suit is decreed, we cannot convince ourselves to take such a paranoid approach, to make out a case for the plaintiff for damages on account of loss of business, where the plaintiff itself could not make out such a case from the materials pleaded in the plaint or the materials annexed to the plaint. Full stop. Next para. During arguments, learned counsel for the respondents, in his usual fairness, had contended that the defendants are agreeable, to display their bona fides, to deposit double the amount of security which has been directed in the impugned order, to cover additional costs which may be suffered by the plaintiffs, due to rising costs of replacing the arms, if ultimately the plaintiff was found entitled to the same. Full stop. Next para. In view of the above discussions, we are of the opinion that although the plaintiff has made out a case prima facie for the purpose of establishing that damages occurred to the plaintiff's twin arm due to the apparent negligence of the defendant's vessel in not mooring MWRING its crane, we are not convinced as to there being any fallacy in the impugned order with regard to refusal of the security amount on the count of loss of business. First up, insofar as the reference to a non-existent third twin arm by the learned single judge in the impugned order is concerned, a careful perusal of the impugned order indicates that the ultimate conclusion of the order did not hinge on such observation. Full stop. The said observation was made in the context when the learned single judge was discussing that the non-disclosure of a particular berth is important, since the plaintiff has many facilities in other berths, including in HOJ, II, and III, 3IZ. Full stop. Even if we omit the last III, the ultimate conclusion of the learned single judge cannot differ, because the ratio and logic remains the same, that the plaintiff failed to disclose the transactions of the particular berths to justify its claim that the lack of operation of the damaged arm would fetch it sufficient income which would justify the claim for damages on account of loss of business. Full stop. In view of the above observations, na arekta line add kori. That apart, even if an alternative case is probable on the arguments of the plaintiffs and in the opinion of this court on the basis of the materials on record, it is well settled, not only in intra-court appeals, but in all other kinds of appeals, that the appellate court has to see whether any perversity or patent illegality has been committed by the learned single judge or the court against whom the court against whose order the appeal has been preferred. Full stop. The appellate court cannot substitute its own views merely because a second opinion is possible on the same materials on record, just because such second opinion is available. Full stop. Next para. Keeping in view such cardinal principle of adjudication of appeals, we are of the opinion that There is no occasion to interfere with the impugned order in the present appeal. Full stop. Accordingly, APOT 413 of 2023, along with any application is pending, along with the pending applications in connection therewith, are dismissed without any order as to cost. Full stop. Liberty, however, is given to the parties to rely on the report filed pursuant to the judgment of the coordinate bench in connection with the appeal before the learned single judge when the main injunction application and the admiralty suit itself is being taken up for hearing, in accordance with law. No rest to cost, Sergeant certificate comes. Arekta line at Kudin. It is further clarified that the observations made above are tentative only for the purpose of adjudication of the appeal which arises out of an interlocutory order and shall not operate as res judicata in any subsequent injunction application, interlocutory application, or the admiralty suit itself. Thank you.
May I get a short period of stay?
If
7 days, 5 days, as your lordship, because
very well.
just to
Yes,
we are on a Thursday.
We'll grant the stay. At this juncture, learned senior counsel appearing for the appellant seeks an order of stay. Full stop. In
as my ground is that as if the vessel says as
on the ground that in the event the vessel leaves upon furnishing the security as directed by the learned single judge in the impugned order, the ultimate decree, if obtained by the plaintiff, shall suffer. Full stop. Since we are of the opinion that sufficient arguable questions have been raised in the present appeal, in the above appeal, the same should be tested before a higher forum. Accordingly, stay of operation of the order passed herein above is granted for a period of 7 days from date.
I'm grateful.
Lordship may record, Lordship may dismiss that. I oppose this. Let's just record.
Yes, right. Accordingly, বলে যেটা last sentence টা দিলাম তার আগে তো বলুন last sentence টা কি বললাম?
Because we have already complied with the order.
No, you're
that is the only reason.
There is only with the time.
Lordship may record that I have already complied with the order. Deposit is already made.
এই সেন্সের আগে আরেকটা সেন্টেন্স ঢুকিয়ে দেব সেন্সের আগে learned counsel appearing for the respondents opposes such prayer and points out that the defendant has already complied with the order of the learned single judge by depositing the requisite security, and the detention of the vessel is causing day-to-day losses to the defendant.
Lordship has not got granted even the additional security which my learned friend has offered.
Lordship has dismissed the appeal. Dismiss the appeal. Lordship
No,
has,
but our logic, the ratio of a judgment was.
Lordship has not, because I was also hearing that.
Now he's won the matter. He's become very
no, naturally.
brave.
Naturally.
No, we'll add one line that he'll be at liberty to claim that.
I'm sorry?
No, but that, no, take that point in appeals. That would be contrary to whatever we did.
No, but then you
have recorded
only that submission.
We have only recorded his submission.
Recorded. Lordship has recorded that.
Yes, that has been recorded.
Oh, very recorded.
But I
No,
take it.
So that has been recorded, but we did not adjudicate. That will be one of the grounds.
Lordship. I will never ever.
Your Lordship has dismissed the appeal, right? And so that there is no confusion. That
No,
my
that's why I'm saying. But he has recorded that, but he has not granted. Very good.
Anyway, since it was an order passed in court in hurry, we are sorry. There could have been many other points, but we could not deal with those.
Your Lordship is what your Lordship is
grateful.
I'm grateful.
Extremely grateful.
Thanks. Beautiful.
My lord, one small matter is there.
What's it? Yes.
Very small matter. Will not take me much time. In a few minutes, my lord. আমার বিক্রি হয়ে যাবে আমার বিক্রি হয়ে যাবে
বাড়ি যায় না রূপক তুই তো এইসব বোম্বে কথা বলছিস কেন
take the lead.
The very small point is that I have filed an application before the company court. Good, bad, right, wrong, the application is pending. Now, pending the application, what was the application? The application was that I have paid certain money to the company in liquidation, and
No, what are you hearing here?
Today an order has been passed.
So this is a contempt application. What is?
No. It is from the matter, my lord, company code matter. Just one background is easy for my lord to understand. Even for me to understand also. I'm doing a matter after so many years before this court. But a very small point is that I filed an application before the court on the ground that look, I have purchased the property from the company liquidation. The registration has not been done. I have paid all the money, etc., and I supported documents. FCDB were filed. The matter was pending before the company court. Disclaimer. Yes, a disclaimer. And what was the prayer? I will come later on. Matter is pending in court. Now, what was my prayer? That let the official liquid disclaim the property and registration may be done in my name. That is pending. Even today it is pending. Pending my application, just the last day of the vacation, hurriedly an order has been passed.
Yes, Mr. Banerjee, something.
Lordship has granted me stay for 7 days, but that would over here is that your Lordship will have to continue the stay granted by the single bench.
Continue the stay granted
By the division bench, your Lordship court, because stay of the order means that the single bench order revives. Lordship has got what I'm trying to say. So the stay directed to continue by the coordinate bench, that should continue for 7 days. Have I been able to explain?
Yes, you have been, but
Because otherwise, the Lordship stay means the trial court judgment will continue.
bring Mr. Ramadan. Yes, continue, please continue. Mr. Mitra, yes.
Yes, my lord. So what really happened? Pending my application, order has been passed the last day of the court, directing the official account to sell that particular property, whether I have a claim. And the sale will be done on 7th of this month. Now the simple question is that today, I will come to the appeal paper or letter, but I'll just give you a background today. Good, bad, right, wrong. Good, bad, right.
What is the application for? What are you praying here?
We start with page number 26.
What is the prayer?
Prayer. Yes, my lord. The Lordship will come to the prayer. Just give me a second time, let me take the prayer. Lordship will come to page number 26 and prayer is at page number 27. Page number 27.
27 of what?
Of my stay application.
এইটা বলছে
হ্যাঁ stay application দিয়েছি তো stay application my lord what huh volume 1 is
yes
26 is the starting of the stay application. Lordship will see the prayer A and order be passed directly the official liquidator honorable high court at Calcutta.
Why can't you wait till after the vacation?
No. What is that? Why can't wait? I can always wait. My Lordship is the last page of my order. Lordship is the last page of my paper to pay volume 3. Last page. Lordship will see the last page and volume 3 at page number 327. Lordship will see the property. What the difficulty I could have come. In fact, I was coming with my family on 8th. I thought of doing the matter, but then I thought I cannot do it. Lordship will see the order. Lordship will pass at page 377. The e-auction to be conducted through the website such and such on 7/11/2023. I have no other option. So my application is pending, my lord. Good, bad, right, dog, anything has happened, lord. Only what I'm praying, my lord. What I'm praying today. Nobody will be deprived. The property selling has been waiting for so many years. My application pending, even I'm assuming I have filed a false application, assuming. Although I never do it in my life. Because I'm the officer of the court first, then the agent of my client. But anyways, my lord, my application is pending. Lordship will dispose the appeal today itself with the direction that let the trial court hear my application and in the meantime the auction be stayed. If the auction takes place, my lord, Lordship will take, otherwise auction takes place, he gets be the bidder. And my application also.
No, what is your claim? Please repeat, Mr. Mitra.
My claim, Lordship will see my prayer. Again.
What is the basis of this prayer? What is your claim? You claim title to the property, undivided half share.
Yes, I have paid, not today, in 2006, 8 crore rupees. Today, the money value comes some 70-80 crore and all supporting documents are there. Not only that sale was done and before the AIFR, BIFR, way back in 2007-8. So it's all 13-14 years back. The company went to liquidation, company could not run. They were in toll dumps, etc. was going on. They went to liquidation, everything was happening. My application pending, my lord. That's what I'm trying to say is that assuming I don't have a case, best case of the other side will be that I don't have a case. That nothing cannot be more than this. Nothing can be more than this. Assuming if I don't have a case.
Yes, Mr. Mujumdar, what do you say?
It's not a sale which is being conducted.
One more thing, Lakshmi, I want to add. I have paid the money, and the court, I will show you before my lordship that you participate in the auction. I will buy my house second time. How is that possible, my lord? Now I will show the order, my lord. This is something order. When I was reading, I was not able to understand how to draft my appeal. I will show my lordship. He has given me. I will read the order of my learned trial judge. My own property, my lord, I paid to the value 70-80 crore.
The applicant is an alter ego of the company in liquidation. That there are at least 20 documents to show on record that it is being set up by Dunlop India Limited. Number 1 and 2, stall the auction. Number 2. Number 2. Now he claims to have entered into an agreement in 2006.
Mr. Mujumdar, don't finalize the sale.
The sale will not be finalized. Please see the.
We won't grant any stay.
Please see the provisions of the law. The court will finalize the sale ultimately after hearing his application. That's why the her ladyship observed that the petitioner will not be.
Show the
only object is not to
participate in the sale in the auction, Mr. Mitrup. That will be subject to the outcome of the proceeding before the trial. But they won't be concluding the sale. The sale certificate won't be issued.
Yes, this sale is subject to sanction by the court. That's the requirement of the law.
No.
And that's why her ladyship has held that the applicant will not be prejudiced.
May I humbly submit this? Lordship, forget everything. For that,
I have actually forgotten.
No, Lordship, honestly, I have made an application. Assuming the application is the worst application in the world, that is pending without disposing.
Mere filing of an application is not sufficient.
Without disposing of application, how can where I have given document to suffice that I am the owner?
Yes,
let the auction be and let trial court dispose my application. What I'm asking today, my lord, let the trial court dispose of my application till such a few days, because courts are opening after 10-15 days. Within
if they don't finalize the sale, that will be whatever e-auction is conducted. That will be subject to the outcome of that.
Yes, that's
the subject of my application 83. Like that, yes, I'm happy.
One indulgence, lordship would kindly.
We're happy. We're also happy. Yes.
Yes. Just I read the opening sentence of this particular rule. Sale to be subject to sanction and to confirmation by court. Unless the court otherwise.
What are you please?
That's rule 272 of the company code.
আমি বলছি যে যতক্ষণ পর্যন্ত আমার অ্যাপ্লিকেশন ডিসপোজ হচ্ছে না সেল কনফার্ম
there is a second
আমার পারপাস সলভ হয়ে গেল হ্যাঁ ঠিক আছে
That's what the court intended. The applicant will not be prejudiced.
That has to be, yes.
That has to be
subject to confirm.
And unless his intention is to stall the auction for the last 4 years, which he has successfully done so far. There is no other objective for filing this appeal.
Not like that. See,
Mr. Mitra, at this juncture, we want to stop the.
No. Lordship, I've understood. I have understood what is going in my mind.
You are understood. You are happy. Then let us pass the order.
No. May I humbly submit? Lordship can pass order like this. Even auction takes place, the auction will skip in a seal cover till the disposal of my application.
It's an e-auction.
One thing, lordship would kindly allow me.
2021, not the price has to be directed to me.
Yes, Mr. Pasu, so.
Yes, I was appearing for one of the workers who participated in the proceeding wherein the order of 19th October 2023 was passed. Now, my senior Mr. Chaudhary was appointed as amicus in this matter to represent the workers. We have not been served with a copy of the appeal. Now, interestingly, lordship would see from the order dated 19th October 2023 that the order was passed such that some money can be given to the workers.
Yes.
Yes, and my lord, if lordship would see, my lord, the conduct of the official liquidator in the matter, my lord, because my lord, on 18th October, a list was submitted by the official liquidator indicating what are the properties that are required to be sold. And my lord, only one property that has been put to sale, and my lord, plant and machinery of the property has been sold. As of now, my lord, the official liquidator, as per the recordings made in the order, he has, my lord, 46 crores and odd. But I am only humbly beseeching your lordship that a copy of the order, a copy of the appeal papers be served on my advocate on record. And my lord, in the meantime, lordship would kindly not stall the sale in any manner whatsoever. Let the sale proceed. Because my lord,
Oh, not stalling the sale, Mr. Basu. We cannot stall. We would not stall the sale. Definitely, we won't stall after hearing this.
grateful. Because my lord, workers are there, workers have died, my lord, the widows are not being even paid, my lord, because my lord, there are serious issues regarding the succession certificate. And my lord, this is going on since 2012, 2014. My lord, I don't know whether your lordship has been handed over the paper or the list of properties that was.
This dispersal was independent of the sale.
Yes, that is what I'm
This
saying.
dispersal has nothing to do with the sale. The official liquidator already has a fund of rupees 43 crore and odd.
Yes.
And from that, a particular sum was directed to be disbursed to you, to the workers. So you are not affected either way. Why are you necessary party to this also at all?
No, but the only thing is that since we were present when the order was passed on 19th of October,
Mr. Basu, nothing hinges on the sale regarding your right to get that money.
Very
That
well.
direction is there. We definitely won't interfere with that. We cannot even dream of doing what. Why should you do that?
Grateful.
May I humbly submit what Mr. Basu was saying?
No, that we are not, because that is
Under
an independent direction. No. So we will hold that should we dispose of the appeal itself?
Lordship can dispose because Lordship can dispose only what I'm saying.
We're not willing to grant stay.
No. I'm not asking for stay. Let the auction be there, but no action to be taken place till the disposal of my application. What that I'm saying. But otherwise, what really happen is that
the court will ultimately finalize the sale. That's the requirement of 272.
No, because my application is pending. Today my application is pending. That has not been disposed of. Until Lordship, what will happen then? Lordship will
Please have a look at page 127 in the second volume.
What Lordship?
Why is he apprehensive? Please have a look at 127 in the second volume.
What?
But this is going on since 2021. And the official liquidator has taken possession in 2017 of his property. Claimed property. In 2013, the State Bank of India said that you cannot interfere with this property. Still then a subterfuge agreement is entered into. I don't want to show this to your lordship at this stage. Please have a look at 127.
I will show document.
Now the second paragraph on that page.
My position.
The applicant relies on documents to show that it has a right of preemption as regards that this is my application. So in other words, if Dunlop and presently, if the official liquidator who is the custodian of the assets.
He is trying to eat my property.
We'll request the learned trial single judge to the learned trial judge to take up your application prior to confirming the sale.
My lord.
In 65, he is admitted and 50%.
Lordship.
We'll request the learned single judge, the learned trial judge to take up your application prior to confirming the sale.
Yes, that will help me.
Learned counsel for the appellant. খুব সাবধান এখানটা একটুখানি ইয়ে হয়েছে ঠিক আছে তো learned counsel for the appellant contends that during pendency of an application of the petitioner for a direction on the official liquidator to disclaim undivided half share of the concerned property at 46 capital B, Chaurungi Road, Kolkata 7,71,, the official liquidator is proceeding with an e-auction sale which is scheduled to be held on November 7, 2023. First up, it is argued that unless the rights of the appellant are adjudicated, the sale should not go through. First up, next para. Learned counsel appearing for the official liquidator.
No. Official liquidator is no difficulty.
You are for respondent number?
My property.
Did I appear for respondent number 2?
Learned counsel appearing for respondent number 2 submits that
He wants to eat my property.
In any event, in terms of Rule 272 of the Companies within bracket court bracket closed rules, 1959, unless the court otherwise orders, no property belonging to company which is being wound up by the court shall be sold by official liquidator without previous sanction of the court, and every such sale shall be subject to confirmation by the court. First up, next para. Learned counsel appearing for the workers in the concern argues that the said workers ought to be impleaded, since a direction of disbursal of a particular amount was passed in favor of the said workers in the impugned order as well. First up, we find from the impugned order that the direction of disbursal of the amount of rupees 30,000 each to 1,200 workers stands on an entirely independent footing, based on the observation of the learned trial judge that the official liquidator presently has a fund of rupees 43, 62,05,979, and nothing hinges on the sale with regard to such disbursal, full stop. Hence, the workmen of the company are not necessary parties to the appeal. Full stop. Next para. Insofar as the merits of the appeal are concerned, learned counsel for the respondent number 2 is justified in arguing that sufficient protection has been afforded in Rule 272, inasmuch as the sale cannot be concluded unless it is confirmed by the court. Full stop. Next para. Keeping in view the balance of convenience and inconvenience of the parties, APOT 414 of 2023 along with ACO 1 of 2023 are disposed of, with a request to the learned trial judge to take up the application
83
bearing CA number 83 of 2021 pending at the behest of the present appellant before the learned trial judge prior to confirming the sale proposed to be held on November 7, 2023. Full stop. It is made clear that the merits of the allegations and counter allegations have not been gone into by this court, and it will be open to the learned trial judge to decide all issues independently in accordance with law.
Only one line, may I?
No rest of us.
May I just request? Lordship can add like this that whatever happens will be subject to the order of this application. Sale.
So whatever happens cannot
Sale,
happen. If there is an
sale.
earthquake,
That's
suppose. If the High Court building falls down, how can it be subject to the result?
The e-auction, what I'm talking e-auction will be my lord. The e-auction will be subject to the outcome of my
No, that has been. Tell Mr. Ghosh no.
Grateful to your lordship. What really happened after?
Well, we are not in a mood to gossip now. Yes, Mr. Banerjee.
That steep portion, as I said.
Yes, Mr. Rambhadran.
It should be.
My lord, Mr. Rambhadran has left, but he's got a flight to catch, so he left, my lord.
What we intended was to extend the interim order granted earlier by the division bench of this court. Otherwise, it would
My lord,
carry no
the
meaning.
pleasure would be to extend it for a week.
7 days, 7
My lord, my lord.
This ওই অর্ডারটা কারা নিয়েছে আপনারা নিয়েছেন যেটা আগে ওই অ্যাডমিরালটি ম্যাটার লাস্ট পোর্শনটা যেটা স্টে অফ অপারেশন করলাম ওটা বলছি দে উইল বি স্টে অফ অপারেশন কি বলেছি একটু বলুন তো the order of stay granted on what is the date, Mr. Banerjee?
26th of October.
Granted on October 26, 2023 by a coordinate bench in connection with this appeal shall stand extended for 7 days from date.
Grateful, my lord. Grateful.
I'm grateful to that.
Till কবে করে তো till 7 days, that is till we are on second to that is till the midnight of November 9, 2023.
November 9.
Midnight of November 9. Midnight করে দিলে সুবিধা আপনার Yes, Mr. Banerjee, anything else?
No, I'm grateful, man.
No.
Grateful, my lord.
I'm really kind. Your lordship is very kind, man.